on, mask. I don't know what for.
What are you doing?
I can't wear those N90.
The court is calling case 22-2094 in the matter of the people of the state of Michigan here today for calendar conference. Appearances for the record, please.
Kevin Battersby Whitnock on behalf of the people, Your Honor, P85532.
Good morning, Judge. Richard Bland, 32990 for Mr. Lacy. He's on the call.
Mr. Lacy, your name?
Mark Lacy.
All right, Mr. Glanda, this is the first time I'm seeing the case. I know there's several things to discuss, but I want to do some preliminary questions first. Mr. Lacy, would you kindly spell me your first and last name?
M-A-R-K.
Last name?
L-A-C-E-Y.
And how old are you, Mr. Lacy?
33.
Are you a U.S. citizen?
Yes.
All right, Mr. Lacy, I'd like to ask you at least one question under oath. If you would kindly raise your right arm and take an oath to tell the truth. Do you solemnly swear to tell the whole truth, nothing but the truth, so help you God?
Yes.
All right, Mr. Lacy, the prosecutor and Mr. Glanda are both present in the courtroom. They likely have other responsibilities in this court, and you're present on Zoom. It is okay that I conduct this case on Zoom technology, but I need your permission to do so. If you would like to be present in the courtroom with your attorney, I'm happy to give you another date to appear inside of my courtroom, be here in person. Is it okay that we proceed on Zoom today, or would you like another date to be here in person?
It's okay. We can presume.
All right, and Mr. Lacy, if you can't see or hear, interrupt. It doesn't matter who's talking, and bring it to my attention. Understood?
Okay.
All right, Mr. Glanda, the docket sheet indicates that this is a calendar conference. Please confirm that your client was present and given advice of rights, or would you like me to repeat?
No, he was.
Okay, fair enough. And I also am in receipt of a settlement offer notice of acceptance, but I then also was receipt of a register of actions that might allow for the conclusion that your client has additional cases forthcoming. So would one of you speak to it?
I will. There was an offer made just this morning on this matter before you. I haven't even discussed it with my client yet, but it's kind of moot at this point because he has a second case up for exam June 7th before Judge Archer, 36th District Court. So assuming that that case is either going to be dismissed on that date, June 7th, or if he is bound over, being on bond, the arraignment date here, Frank Murphy, would be 2 weeks, June 21st. So I'm asking that this matter be put over to June 21st, assuming that that second case is bound over with come to you.
Noted, Mr. Lacy, if in fact you are bound over to the circuit court from the district court following a preliminary exam, yes, you will be having me as your judge because we're going to keep all of the cases in front of one judge. It makes sense to me what you're asking. I trust that the people don't have any disagreement. Mr. Whitnow?
We do not, Your Honor.
Okay, let's stick with this case for a moment. Regarding discovery, are the people waiting for anything?
No, Your Honor.
And Mr. And so you're in, have complete discovery?
Yes.
All right, and Mr. Lacy and yourself, Mr. Glanda, at the previous arraignment on the information were advised of the habitual offender third notice. Please confirm. Okay, fair enough. All right, Mr. Lacy, you must keep your address and phone number current at all times with Mr. Glanda. I'm not in the business of moving cases around, but if we were to call Mr. Glanda, it's the equivalent of calling you, and you must keep your address and phone number current. Understood, Mr. Lacy?
Yes, ma'am.
All right. So, Mr. Lacy, I'm going to schedule the next hearing date on Zoom technology. You are welcome in the courtroom. Mr. Glanda would know what to do. In summary, you have to be on the guest list at the front door. We are still required to know who's coming in the building for compliance with mandates to government buildings regarding the pandemic. All you need to do is have your name on the list, and Mr. Glanda would know how to do that in the event you want to be present at the next court hearing. You can think about it, discuss it with Mr. Glanda, and we'll go from there once you've had that discussion. Mr. Glanda is correct. If the preliminary exam is completed on June 7th, the first time we would see this case is the 21st. That's a date that will automatically given, so why don't we just schedule it on June 21st? You know that we do in custodies first or try to. Mr. Glanda, you're an early bird and always here, but I'm gonna schedule this at 10. If we can get it done sooner, you're welcome to do so. Fair enough? All right, Mr. Whitnoff, anything further you need to place on the record?
There is not, Your Honor. Thank you.
Mr. Glanda, anything that you need to place on the record?
No,
And Mr. Lacy, I'll see you on June 21st at 10 o'clock on Zoom. You're welcome to be here if you choose. Anything else from anyone?
no.
That completes this hearing off the record.
May I approach? So,
I did, but had I known that Brad Fargo was gonna be there, I would have. It was a long, long day here. And I didn't get out of here till 7. Yeah. It's just a long day.
I was in New York.
Yeah, by the time I got home, changed my clothes, went back, I was just too tuckered out. And, Kathy was out of town, Joyce wasn't feeling well, Peggy wasn't well, and Debbie was out of town, my crew. So, that's, talk to you later. All right, I don't know, we're supposed to start this trial in 7 minutes at 10. And I think we have a fairly light docket because we're supposed to be in trial most of the day. So I don't know what's happening. Who was this here? Lacy. Are you going upstairs? Or you going in the jury room?
Well, that depends on timing, Your Honor. If I have time to go upstairs and grab some files, I might do that, but during the trial, I'd like to sit next to Mr.
Oh, you can do whatever you want. I don't care if you sit in the room. I'm just trying to figure out, I don't have any idea what's next because we've got a calendar conference on Gagnon and Hunter. It looks like we should try to get those done.
I'm
Cleary
prepared, Your Honor.
especially assigned. This is that press case that doesn't concern either one of you. It's one. I don't know. Don't know how to answer your question. I don't know what's next.
Okay.
Would your clerk know?
She might, on Gagnon and Hunter, but we're due to start a trial in 6 minutes.
I can leave the meeting now.
Pardon me?
They cannot leave the meeting.
Is that you, Mr. Lacy? Mr. Lacy, is that you talking? Mr. Lacy, yep, you're welcome to leave. Shepherd, what do we know about these calendar conferences?
There are no cases ready to call. There are no defendants court is calling case 20-2931 in the matter of the people of the state of Michigan versus Daniel Brown here today for a bench trial. Appearances for the record, please.
And good morning, Your Honor, and to your wonderful staff. May it please the Honorable Court, Reginald Andrew, P 80354, on behalf of the people.
Good morning, Your Honor. Wyatt Harris, 354-891. I am representing Mr. Daniel Brown, who sits to my left here.
Mr. Brown, your name?
Daniel Brown, please.
Fair enough. And I would note for the record, Mr. Andre or Mr. Harris and Mr. Brown are all present in the courtroom. And Mr. Harris, you had approached my legal staff and me this morning regarding getting someone into the courtroom that wasn't on your witness list. The court is well aware, and the record has already reflected that Mr. Brown receives medical care. And the individual in the courtroom, was there any problem with that? And is that a helper of Mr. Brown?
The gentleman is Samuel, excuse me.
What is it?
Samuel Silas. Samuel Silas.
SAMUAL UELSILAS?
That is correct.
Okay, does he? Nothing to do with the trial, and he's allowed to be in the courtroom? That's where I would like to confirm.
So, okay, Your Honor, so this is the only person, Mr. Silas, who we want as a spectator.
That's fine. I just want, I know that there was an issue. There's still an issue about getting into this building. Please, as a friendly reminder, Mr. Harris, there is a book, like a guest book on the council table. Please make sure that Mr. Brown and Mr. Silas sign it. We are still required to identify who's in our courtrooms to remain in compliance with the COVID restrictions. We have to know who's in the building. But I just wanted to make sure and place on the record that your client's request to have someone brought into the courtroom today was accommodated and successfully upstairs.
They have signed it.
Perfect. This is a bench trial. There's already been a waiver of a trial by jury long ago. I believe that was in place as of October 5, 2021. Today is the date and time scheduled for the bench trial. Are both parties prepared to proceed? Mr. Prosecutor, ready to go?
Ready, Your Honor.
And Mr. Harris?
Yes, ready, Your Honor.
Any motions or preliminary matters? Mr. Andreer? How about you, Mr. Harris?
Your Honor, I have one motion and then
Okay.
Your Honor, the date of the incident occurred on May 5th, 2020. At that time, no one was arrested. No one was taken into custody. On June 7th, 2020, the complaining witness called the police. My client was at a location of 1675 Steel, which is next door to where the complainant was residing. When the police arrived, they recognized that there was a non-in-custody warrant. They took my client into custody. The police indicated that they observed my client toss a pink backpack in this silver car, silver Hyundai. They took the car. A day or two later, they together a search warrant to search the contents of the car. And inside that car was a .40 caliber gun under the driver's seat. The complaining witness has testified, I'm not sure what he that he observed a black handgun back in May of 2020 being pointed at him by my client. I would ask that the to prevent the prosecutor from presenting any evidence that, of the contents of that car, especially the gun. My reasoning for that is twofold. There's no exact description of what the gun and no exact match of the gun that was found in June 7th of 2020 to any alleged incident that occurred on May 5th, 2020. I believe that the rescue of this gun was too remote in time, and there are millions of 40 caliber Glocks out there, black Glocks out there. So I would ask that the court not allow the prosecutor to present that evidence because of its remoteness in time, because of the fact that there are many black Glocks out there. We can't connect the handgun that was allegedly pointed at Herndon on May 5th.
And Mr. Who, counsel?
And Mr. Herndon, Hernton. And the 40 Glock that was found in June 7th.
Response, Mr. Andrea?
Yes, Judge. Judge, at this time, people request this court deny defense counsel's motion. Judge, this incident stems from a felonious assault using the defendant used a black 40 caliber handgun, which is a complaint witness described to a T back in the preliminary examination and to the officer that arrived on scene on the day of May 5th when the felonious assault happened. The only reason no arrests were made is because the defendant fled the scene before police arrived. At that point, the police officers had to initiate an out of custody warrant to be signed by my office. It took them about 4 weeks to be able to locate the individual because he was never at the residence or locations that the complaining witness had given to the police officers as a possible location where they could find him. So it took some time, although the people would say that 4 weeks is not so remote a time. The defendant was found with the vehicle that the complaining witness identified to the police, with the gun that the complaining witness identified to the police in that vehicle. So people would ask that defense counsel motion be denied.
Complete.
Thank you.
Mr. Harris? Was there, well, let me ask both parties this, was there a preliminary exam in this matter?
There was, Your Honor.
And I'm assuming, and perhaps, I don't want to assume anything. I take it that at some point in time, there was a statement taken by from the complainant by the police. Where are we reaching the conclusion of what the complainant described? The complainant, I think these are your words, Mr. Harris. The complainant testified black handgun pointed at him by the defendant. I believe I'm quoting you somewhat accurately. And are you claiming that that is the only identification that the complainant gave the police was a black handgun? And where I'm going with this is the thought that I don't have enough information in front of me right now to make a ruling on the motion in limine without first hearing from whatever testimony is going to be presented to this court as to whether or not there is an adequate description to tie bar these two instances together on or about a month apart. Do I understand your argument? Yes. You're asking me to prevent, I presume it would be evidence of the search warrant of the contents allegedly of Mr. Brown's car over a month later.
Yes.
And
Of
your
a car, not Mr. Brown's car. It is a car.
a silver car.
Silver.
Okay, I heard your argument that the complainant allegedly described the car and the gun in detail, but I haven't heard that testimony yet. And I hear your argument regarding remoteness of time and how could a quote unquote black gun, an inference be made that it was the same gun, but I haven't heard enough specifics to see whether or not there is enough evidence to allow the prosecution to move for admission of this search warrant without hearing the evidence of the description. You know, your argument is that it's a month away and it's a black gun. Mr. Dreyer, in his argument, said that the complainant gave complete description. I don't know what that description is. So you can object at the time and I'll hear further argument after I hear from the complainant.
Just because it is a matter of the court.
Go ahead.
If the court would look on page 8, line 16 of the preliminary exam transcript.
All right, I don't have the transcript in front of me right
Oh,
now.
you
So,
want a
but I
copy
can
of
get it.
transcript?
I can get it.
I have a copy if you need.
I'm happy to look at your copy. I know that you're the third counsel on this, I believe, Mr. Harris. I'm looking through my notes. I may have never read this transcript. If there wasn't a motion to quash and or a bond motion.
Take the transcript, you know.
No, I don't have a copy of the transcript. I'm looking for the file. I've done a motion regarding withdrawal of two different counsels to amend the tether, removal of the tether. I'm looking to see if I've ever read the transcript.
There's a copy of the transcript I have from.
You may. Thank you.
There you are.
And noting for the record that Mr. Harris just handed me a copy of the preliminary examination transcript for the Honorable Ron Giles, 36th District Court Judge, August 11th of 2020. And this is a very short transcript, 22 pages in length. And you're directing me to what page, Mr. Harris?
I'm sorry, Ron.
What page were you directing me to?
I'm directing you to page 8, line 16.
All right. And I'm looking at this quickly. The transcript handed to me by Mr. Harris does not include any personal notes or highlights. Would you confirm, Mr. Harris?
Yes. My client would like some water.
We can arrange for that. Boy, it's been a long time since we've had a jury in this courtroom. We have cups in the back and we certainly have a water cooler. And I see that Madam Clerk has already gone to retrieve saying we're happy to accommodate that, Mr. Brown. All right, so you have directed me to line 16 on page 8 that says, in response to the question on line 15, what did you see in his right hand? Answer, a black handgun. That's the only, that you're highlighting that as the only description given, correct?
The description that he's given.
Any response, Mr.
I'm sorry,
Andre?
Judge, I was talking to co-counsel. Can you repeat that, Judge?
Mr. Harris handed me the transcript.
Yes.
Line 16 on page 8 is an answer in response to the question on line 15, and I read both into the record. Line 15, it has Q for question. What did you see in his hand? 16, capital A black handgun. You're alleging that that is the only description in the transcript, Mr. Harris.
Yes.
Just a moment, Your Honor.
No problem.
Judge, I would stipulate that that is the only description of the handgun in question in the exam transcript.
Okay. Once again, Mr. Harris, you're asking me to make a ruling via your motion in limine about the relevance of this find allegedly on 6/7/2021. I understand your argument regarding tie barring these two dates over a month apart, and your argument regarding the relevance of an alleged black gun found via the search warrant. I would agree with you that a black handgun is certainly a vague description on line 16, page 8 of the preliminary exam transcript. But once again, the court hasn't heard the testimony of the complainant, nor is the court aware of any other description that may or may not be found in police reports, exception, et cetera, that could be used during the course of this testimony. And I'm going to rule on your motion in limine following testimony from the complainant to determine its relevancy.
Thank you, Judge.
All right, now you just made mention that you were talking to co-counsel. There is a second prosecutor in the room. If you'd like to identify yourself, sir.
Yes, Your Honor, Kevin Battersby Whitnoff on behalf of the people, P85532.
Both parties prepared to proceed.
Yes, Your Honor.
Mr. Andrea, would you like to make an opening statement at this time?
Judge, the people waive opening at this time.
Now we're reserved.
No, Your Honor, I'll make an opening at this point.
All right, fair enough. Do you have any objection to the prosecutor waiving his opening
No
statement?
objection at all.
All right, go on.
Your Honor, this case is about a complaining witness, Mr. Perron. And it is about an address, 16165 Steel. That is a location that the evidence will show that Mr. Herndon was squatting in. This property is owned by a Josette Crumble. Ms. Crumble, the evidence will show, is Mr. Brown's mother. Mr. Herndon was squatting at that location under some false pretenses by other family members of Mr. Brown. Mr. Herndon changed the locks on this property so that Ms. Crumble could not get inside this property. That's where the problem begins in this particular case. The actual incident occurred at 16175 Steel. That particular location is directly next door if you were looking at the house from the street on the right-hand side. It is a yellow house, the 16175 location. And the 16165 location is a red brick house. Miss Crumble had been trying to evict Mr. Herndon from this location for some time. May 5th, 2020, or excuse me, maybe February, March of 2020, COVID hits. And it hits bad. It hit so bad that Miss Crumble's daughter, Mr. Brown's sister, died. The owner of this hacienda.
Wait, the owner of this,
The Hyundai car that Mr. Herndon is claiming that Mr. Brown was in pointing a weapon.
and the sister is the owner of this car.
Correct. But she passes away in April of 2020. Miss Crumble's aunt and a number of other family members have died prior to this May 5th, 2020 incident. And it puts the family in an absolute tizzy. Mr. Herndon sees an opportunity. So what Mr. Herndon does, and what the evidence will show from Mr. Herndon, that he was at the 16165 address and that Mr. Brown points a gun at him from that address. Now, it's very, very key, these two addresses. The evidence will show that Mr. Brown was at 16175 in the driveway with a Deborah Walker. Ms. Walker calls Mr. Herndon over to the location and says to Mr. Brown, let's stop this argument that they have over another separate weapon. And the evidence will show that no gun was pulled on Mr. Herndon at that 16175 address. Mr. Brown did not have a gun at that address, didn't point a gun. There was a discussion. The discussion, the evidence will show, was not a heated discussion. Mr. Brown left the location, Mr. Herndon left the location, and Ms. Walker, Deborah Walker, the neighbor who has been in that house all of her life, left the location and went inside her house. Mr. Brown makes a phone call to the police and called them over on May 5th, 2020 and say a gun was pointed at him at 16165 Herndon, Steel.
Stop for a second. Did you say Mr. Brown called the police over on that day?
Mr. Herndon
Mr. Herndon, okay.
called the police and said a gun was pointed at him at that 16165 address. What's the problem there? Problem there is real simple. Mr. Herndon has to say that because if he says 16175, that causes the police to have to investigate that location where Deborah Walker lives. And that also will have to have the police talk with Deborah Walker to find out if she was home, what happened, all of that activity as to whatever this incident is. Well, the police ultimately do talk to Deborah Walker. And they talk to Deborah Walker at the behest of Mr. Brown, Mr. Daniel Brown. And Mr. Herndon will tell you, and has said on direct examination from the preliminary exam, that no one was out there with Mr. Brown. And then on cross-examination, oh, by the way, yeah, Dee Dee, she goes by the nickname Dee Dee, Deborah Walker, was out there. And that will be the first time that Rhonda Herndon has told anybody that somebody else other than Mr. Brown was out there. Because mind you, Mr. Herndon has spoken to the police on May 5th. He spoke by telephone to the police on May 7th. That interview was an interview to identify what happened and to identify Mr. Brown. And oh, by the way, in that interview, Mr. Herndon tells the police that he had to evict Mr. Brown from that location.
No.
Yes.
No,
yes.
Herndon
Yeah.
told the police that he had to evict Brown from the location?
Yes,
Okay,
I told you it was all about this property. So, and at that time, and I provide some evidence to the court to that effect, Mr. Herndon didn't own the property, didn't have a lease to the property, didn't rent the property. Ms. Crumble will testify that she has made no agreement with Mr. Herndon about that property. And that's why I call him a squatter. Because he's really got no business being, first of all. So he starts this story off with this incident occurring at 16165 Hampton Steel. And I say he named Mr. Herndon. And he then is still living at that property on June 7th, 2011. 2020, excuse me. 2020. And he tells the police that he's got a PPO out against Mr. Brown. There is no PPO against Mr. Brown. And let me remind this court that Mr. Herndon is a convicted felon, not be able to establish by rule.
complete.
And he alleges that there's a felonious assault going on, but no one acts upon that. They act upon the outstanding out of custody warrant that Mr. Brown has from the May 5th, 2020 incident. Deborah Walker, Dee Dee, talks with Mr. Herndon a couple days after this discussion, after she learns somehow that he has called the police, that Mr. Herndon's called the police. And asks Mr. Herndon, why are you doing this? Mr. Herndon says, Miss Crumble knows what I want. And if she's able to give me what I want, this property at 16165 Steel, I'll stop whatever prosecution is gonna happen. Fast forward after May 5th, Josette Crumble has a conversation with Mr. Herndon. And Mr. Herndon tells Ms. Crumble, I don't want your son to go to jail. She also has a conversation with Mr. Herndon, and Mr. Herndon says that he had talked to Ms. Crumble's brother and that they had made this arrangement for him to get this property but Mr. Williams did not own the property.
Who's Mr. Williams?
This
Crumble's brother.
So, Your Honor, a lie has to be made about this property in order to satisfy Mr. Herndon's motivation to get the property. Mr. Herndon wants to move, keep staying in the property along with his family. He has that as a motivation, and he accuses Mr. Brown of pointing a firearm at him. And that testimony, the evidence will show that that never happened. And that will come through Deborah Walker, who was finally interviewed by the police in October of 2020. after a review of this testimony, this evidence, the court will find that it's absolutely not credible. And the court will understand that this incident did not occur. And this court will find Mr. Brown not guilty of.
Before you sit down, Mr. Harris, and before my stenographer looks at me, would you spell crumble? And when you spell,
CRUMBLE.
all right.
And
Yeah.
Josette is JOSETTE.
Her first name, Miss Crumble's first name is Josette,
Josette,
and that is Mr. Brown's mother.
correct.
The complainant's spelling of his last name is,
HERNTON.
Harrington.
His first name is Karande. KARONDI.
And let me just confirm, the yellow house at 16175 Steel is Deborah Walker's house.
Yes,
And then the other address in question is 16165 Steel, the red brick house.
yes,
And your opening claims that the red brick house is owned by Miss Crumble.
correct.
And the houses are next door neighbor houses on the same side of the road.
Correct.
All right, that just clarified it. I think I've gotten the answer I needed regarding spelling.
Okay.
Call your first witness. I'm assuming that there's a motion to sequester witnesses both by the people and the defense.
Yes, Judge, any and all witnesses that testified today, I would ask to be sequestered at this time.
All right, Mr. Harris. Mr. Brown, just give us a second. Mr. Harris, I'm going to grant a sequestration motion for both prosecution and the defense and require you to police your own witnesses.
Yes.
Is there an OIC coming in, Mr.
No, Judge, not at this time.
All right, just asking if there's an exception.
I would ask for the exception in case she does decide to, she wants to come in and observe.
Well, you can identify her if and when that happens.
Absolutely, thank you, Judge.
You have somebody coming in?
Judge, I was just learning some new information from co-counsel about one of our witnesses. Yes, at this time, the people would call Karandi Harrington. Him.
Yeah. All right, let me double check protocol here. I believe that we're not using the plastic, but here is a face shield for this witness. And Madam Clerk, I think that I'm looking at this and all the film is off. Okay.
Mr. Harris,
All right, I want you to stop right there.
I'm sorry, excuse me, Mr. Harris, just be mindful when you guys are rustling through the paper that that mic is there. And I'm picking it up, and that's what I was trying to suggest to your client. Wasn't about your mask, it was about the rustling of the papers. Be careful.
Just like the handles.
Okay, got it. So just put it right up there. Hold on just a second. We got too many things going. We wipe down the handles of the chair. We bring in disinfectant wipes.
That's
Why
just
don't
for the
you put
next- that's
down-
just for the next after these.
Right, but let's put it next to the chair just in case the witness would like to utilize one. And would you also, Mr. Bowman, bring down the sanitizer so it's just more accessible to the witness? Fair enough. Sir, if you would come forward and raise your right arm, stand in front of Madam Clerk.
Do you solemnly swear or affirm that the testimony you're about to give in the matter now pending before the court is the truth, so help you God?
All right, and you have a seat to my left here on the witness chair. You're gonna find that there is a face shield for you. And that's brand new. We've taken the protective film off on each side. No one has ever worn it. Put it on, then you can put your mask down. There is hand sanitizer and sanitizing wipes at your pleasure. We've already wiped down the chair as well for you, sir. So put that
Do I have
on.
to use this?
I think you have to,
Okay, okay.
because we're gonna ask you to pull your mask down.
Okay, I understand. Thank you.
Because we can hear you better
I
that way.
understand.
Okay, fair enough. Tell me your name, sir, and spell first and last.
My name is Karan D. Harrington,
Spell both.
Karondi. Last name Hernton.
Hern as in Nancy, T as in Tom, O-N as in Nancy.
Correct.
All right. Hernton, is that how it's pronounced?
Yes.
All right, Mr. Hernton, both the prosecutor and the defense counsel are gonna ask you questions. Obviously, you've taken an oath to tell the truth. Do not guess, do not assume. If you don't understand their question, tell them that you don't understand the question, and I will make sure that it's, re-asked of you in a manner and fashion that you do understand. Never guess, never assume. And we're all getting used to the masks, the plexiglass. The lady in front of you is transcribing. We're also recording this entire proceeding, so make sure you speak up loud enough so that everybody can hear you and we can record properly.
I understand.
Fair enough?
Yes.
Mr. Andrea, you may begin your direct examination. This is the prosecutor.
Thank you, Judge. Good morning, sir.
Good morning.
I'm gonna ask you a few questions, probably more than a few. If you can't hear me, if you don't understand the question, just stop me. I'll speak louder. I'll rephrase the question.
Understood.
Okay, thank you. Can you please state your name again for the record?
Karan D. Harrington.
And sir, can I ask you to think back to the time of May 5th, 2020? Do you remember that date at all?
I don't remember the exact date. No, I do not.
Okay, so,
I remember the situation in May.
okay, so on or about May 5th, 2020, were you at the location or near the location of 16165 Steel in the city of Detroit, county of Wayne, state of Michigan?
Yes.
And what's at that location?
But at the time, my residence,
At the time that was your residence?
yes,
So you no longer reside there?
at that particular house. I still live on the same street as a few houses down.
Okay. Now, on that date and at that location, do you recall what you were doing?
I was at home with my children,
You remember what time it was?
daytime.
Daytime, so it's light out?
Yes.
And so you're at home with your children. Did anything occur that took you out of the home?
Yes,
What happened that brings you here to court today?
I was at home. Daniel Brown, sitting right there, who had formerly lived in the house that I was occupying, was upset that I evicted him from the house and took over possession from his uncle.
Okay, now, you said it was Daniel Brown.
Yes,
Do you see Mr. Brown here in the courtroom today?
I do.
Now, I want you to take a look, point to his location, tell me something he's wearing.
He's wearing a sling on his arm and a sweater with white sleeves and brown patches on it.
And where is he sitting?
He's sitting right in front of me, next to a gentleman in a suit.
Your Honor, please let the record reflect that the witness has just identified the defendant in this matter, Daniel Brown.
So identified.
All right, so you're saying, so let me just clarify. You said Mr. Brown came to your home?
No, came to the residence adjacent to my home,
Okay,
immediately next door. Right, and but from that driveway, he can see and speak to me.
and is that what was happening
That-
on that day?
Yes,
So you were in your home. What made you come outside?
I heard shout
What kind of shouting?
like that nigga know what he did. Something gonna happen to him and that kind of stuff.
So there was an individual, or Mr. Brown was out.
Yes,
Did you see Mr. Brown shouting?
yes,
So he was shouting vulgarities.
yes,
So would you say that he was upset
Yes, he was upset.
Was he angry?
Yes.
Okay. So you heard him shouting these obscenities. Did you know they were directed at you?
No, at the time I did not.
Okay, so you heard Mr. Brown yelling, it drew you outside.
Yes, because
Correct.
the summertime is warm out and the doors are open.
Okay,
So when I hear this noise, I come out, I knew his voice. So I didn't know where he was at.
now let me stop you. You say you knew his voice. How
Mhm.
long have you known Mr. Brown?
I had known Mr. Brown for several months.
Several months.
Yes, less than a year, but for several months, up until the eviction and stuff like that.
Okay, so May 5th was not your first encounter with Mr. Brown.
Correct.
All right, so you came outside and you observed Mr. Brown yelling.
When I come outside, Mr. Brown is sitting in the neighbor's house next door driveway in a gray vehicle.
Do you remember what kind of vehicle it was?
It was a Hyundai. A Hyundai.
A Hyundai, what was the model?
It's I don't know, it's a four-door sedan. It's a gray Hyundai sedan. I don't know, Sequoia or some type of vehicle like that.
All right. So the Sequoia would be the SUV.
No, well, whatever the small Hyundai car is. I don't know the name of it, but it's a Hyundai.
So it's a four-door sedan.
Yes,
Small, large sedan.
small,
Okay.
compact.
And you said it was gray in color?
Yes,
Are you sure it was gray?
yes,
So he's sitting in this vehicle?
yes.
Okay, what happens next?
He's saying, I can overhear him. He's saying, he took my gun. I ain't gonna let nobody take nothing from me. I'm gonna do something about it. He better move away from there. So there's people coming over here and all that.
So at this point, who is he directing these obscenities to? Who is he yelling at?
He's speaking. Now it's a neighbor who house that is. He comes to her house sometime, whether she's home or not, parks in her driveway. And sometime he'll get out and go to her door, and sometime he'll park in her driveway and then for a few moments and leave, right? So this particular day, she's out and he's voicing some concern to her about why he's mad, right?
Okay.
So when she see me outside, she wants to try and resolve the problem.
So at this point, did you know that his aggression was aimed at you?
Yes,
How did you know that?
because I overheard what he was saying. I overheard him speaking to the house next door, and I'm the person that lives in the house.
Okay. So you mentioned he was angry about a gun. Someone took a gun from him.
Yes.
What gun are we talking about here?
When it came time for Daniel to move, he had some weapons in the house. And I had taken possession of the house through his uncle. I leased the house from his uncle for 2 years. I had the lease agreement, and the uncle said, man, I can't go in there for
Objection, hearsay.
Hold on, don't answer
Okay.
that.
Objection, hearsay.
Okay, you can't tell us what the uncle
Okay.
said, I'm gonna sustain the objection.
Repeat your question.
But also, you can't give us a narrative.
Okay.
Just
Right.
answer the question and then wait for the prosecutor to ask another question. Go ahead, sir.
All right, so we were trying to determine what gun
Okay,
was Mr. Brown
he had
referring to.
he had some type of assault rifle.
Okay.
It got a pistol grip on it. It has a banana-shaped magazine, and it's an AR-15 assault rifle.
So it's an assault rifle. It's a
Yes.
long gun.
No, it's a short assault rifle. It's an assault pistol.
Okay.
Right. It's an AR pistol. I don't know whatever it's like that.
I understand. And was that pistol located in the home?
Yes. He left it in the home.
Okay. Now, I want to backtrack just for a moment. You said you signed a 2-year lease
Yes.
with his uncle.
Yes.
So you believe the uncle had the authority to lease the home to you?
He did. Yes.
Okay. And you said you signed it and
I
everything?
paid him. I signed it. It was notarized at my bank. And when we presented it to Daniel, the uncle said,
Well.
I mean, not Uncle
Don't
said.
tell us what the
So
uncle
when
said.
we presented the contract to Daniel to let him know that the house is under different residents, right? He took the contract
Okay, pause for just a
and
second.
tore it up.
Wait,
Oh,
one
hold
second.
on just a second, couple things.
Okay.
Couple things I should have told you before you started. No he, she, they, them, because you've got to understand, I don't know anybody.
I got
Even if you're repeating the name over and over, no he's, she's, they's, them. The other thing you can't do, you haven't done this, but since I'm gonna give you a few directions, no mm-hms or uh-uhs. I never want to guess if that's a yes or no. So go back to, he presented to him,
Okay.
give me all the
you. I
names.
got you. Understood.
Back to you.
Thank you, Judge. Okay, so,
Andre Williams.
And
Who's
what's,
on-
and is that, who is that? The
Andre
uncle?
Williamson. Andre Williamson is the uncle in which I leased the property from.
okay,
Upon me signing the agreement with Andre Williamson and presenting it to Daniel Brown, Daniel Brown was disgruntled about the uncle's decision to lease the property to me.
how do you know he was disgruntled?
Because when the uncle told it to him, he immediately said, "You can't do that. You got to give me 30 days to move to move. You just can't take possession of the house and then say I got to move, and you got to give me 30 days." I said, "No." Andre Williamson and I got a contract that agrees that my lease starts on February the 1st.
Was it February 1st?
It was near that. So
Okay.
so now, as of we're telling you today, which is January, soon before February 1st came, ahead of time, that come February 1st, this is the new arrangement, right? And utilities been transferred, my name and all that.
All right, so what happened on February 1st?
I don't remember exactly that date, but I took possession of the house. I changed the locks and stuff. And that was it. At the time, Dan used to have some possessions there. And there was another woman who had some more possessions there. And I hadn't got the house. The house needed a lot of cleanup and work done. So I didn't mind for him to stay he stayed like 2 weeks past February.
Who's the he?
I mean, excuse me, Daniel Brown he stayed like 2 weeks past February, because when I got the house.
Let me just stop you real quick.
Okay.
Just want to make sure I'm following you.
Okay.
So you take possession of the house on February 1st.
Yes,
Mr. Brown is still living there?
yes.
Okay.
Well, he has his belongings there. He goes and be gone sometime, but he'll come back there and he'll stay for a few nights, then he'll be gone somewhere, then he'll come back, like that.
Okay, and you indicated you changed the locks once you took possession.
Yes,
Did Mr. Brown have a way to get in and out? Did he have keys?
yes, because what would happen is we would never lock the side door.
Okay.
So anybody who knows that, and Daniel was familiar with the house, just checked in, you could put your hand in there and turn the thing and open the door
Okay,
at the time, right? So that was the situation at that time,
all right, so
It
Mr.
was-
Brown
I'm
knew
sorry,
he had,
stop, I'm
Hold
sorry,
on.
that was what at the time,
the
sir?
situation.
so Mr. Brown knew he had access to the home he needed.
Yes.
Okay. Let me ask you this. At what point did Mr. Brown vacate it completely?
The day that, he was there, he had gotten ill.
He?
I mean, Mr. Brown was at the residence, he had gotten ill. I took him to the hospital personally, to emergency.
Okay.
He stayed there he had to have emergency surgery, so he stayed there for a few days. When he got better, he called me. I said, "I'll come pick you up." So
And did you pick him up?
no, someone else, he called me and said, "You don't need to come get me. A friend of mine is coming to get me."
Okay.
But when they came and got him, they brought him back there.
Okay. Now, at this point, when he left the hospital and he was back at the residence,
Right.
was his possessions, were they still in the location?
The weapons were.
Okay.
But his clothing and stuff, we had packed up and put it in a vehicle that he had that was sitting in front of the residence. His TV, his clothes and stuff like that had all been packed and put into his vehicle.
And what kind of vehicle was that?
It was what was that car? A Pontiac. I don't remember. It was,
Okay.
it was SUV,
That's
like
fine.
a small SUV.
That's fair.
Yeah.
All right, so you packed up most of his belongings into this vehicle.
Yes.
Objection, Your Honor. That's not what this witness testified to. This witness testified to is that Mr. Brown's belongings were packed up and put into a vehicle. He didn't testify that he did anything.
Part of the problem is he used the word we,
Right.
and I don't know who the we is.
I apologize,
So
Your
let's
Honor.
go back. We packed
Okay,
up,
it's a gentleman who packed Mr. Brown's belongings. His name, Carl Douglas. He was associate to Mr. Brown.
Okay, so as a friend of his,
Yes.
did you assist with the packing?
I did not.
Okay, but you observed Mr.
Yes.
Douglas
Yes.
packing up the,
Yes,
and you observed him loading up the vehicle?
yes,
And you indicated that the weapons were not part of these loads?
correct.
Okay, now, let me ask you, this, how long was that vehicle parked out there for?
He left it there.
Who's the
Oh,
he?
excuse me, Mr. Daniel Brown left the vehicle there for over 2 weeks, to the point to where I went to the residence in which he was living with his uncle and requested that he move the vehicle.
Okay, now let me ask you. This. So it's been parked in front of your location, in front of your residence for 2 weeks.
Yes,
Where are these weapons now? Where's this AR-15 pistol?
okay. When Daniel Brown came to the residence, you asked me a question that I didn't answer. You asked me when did he leave the residence, right?
Yeah.
He left the residence, Mr. Brown left the residence when he got out of the hospital. He came to the residence. Only thing there of his belongings inside were these weapons. All his other belongings were in the vehicle. When he came there, I told him that the weapons were not inside of the house, they were in the garage, right? So,
So you said they were inside of the garage?
yes,
Now, this garage is part of your property?
yes,
Is it attached garage?
No,
or
it's
detached?
separated, right,
It's attached
right,
garage, okay.
right. So he come, he said, where are my weapons? Was at this time is one weapon, because he had came and he had recovered a handgun, a 40 caliber pistol. Then he had this rifle.
Okay.
So now he just needs his rifle because he has his handgun.
And you observed the weapons that he kept at that location?
Yeah, because he left them in the house. I didn't want to move them out. I had took this in the house and this stuff was in the house, right? So,
Okay, so you observed an AR-15 style pistol,
yes.
what else?
And it appears in a small handgun.
What kind of
It
handgun?
appears to be, look like 40 caliber. It appears to be.
Speculation.
I don't know.
I agree.
Right.
You don't know what it is.
It's a
We'll take
black,
that answer.
a black pistol.
Okay, a handgun,
Yes.
okay. Okay, so you've observed these, so now these weapons, at least the AR-15 is now in the garage.
Yes.
Okay, what happens after that?
He comes, he asks for his rifle. I walk him outside.
Mr. Brown came,
Mr. Brown came,
he came to your door,
he came to the house.
get to the house,
He came into the house
he came into your house,
and he's asking for it. Okay, I said, it's not in the house. He said, where is it? It's outside. We go outside. He recovers it, right?
yeah,
I say, nah. It cannot come in the house. You have to take it with you,
so you didn't want the AR pistol in the house,
him or the AR,
okay,
right? Mr. Brown or the AR.
okay.
So now you got, this is the last thing that you have here. Take it and go. He got it. He had a girl with him. Mr. Brown had a girl with him. What he did with the bag and the weapon once I seen it in his hands.
Yeah.
I do not know. Okay, now,
Okay, so you didn't,
Stop, I'm confused. What kind of bag are you talking
he
about?
had a gym bag, like a duffel bag, gym bag.
and you observed him put the AR weapon into that bag,
Yes,
you observed him do that,
yes.
so you're indicating that you don't know what he did with that bag once he left.
Right. Once I know that he had his weapon in his hand,
Mhm.
right, I went inside the house. He stayed outside. He never came back in the house. So I don't know where he went, but the vehicle remained at the house for 2 weeks after that. So it was always my assumption. I say to him this, when he come and say, when I find out that he's upset, accusing me of stealing a weapon from him, I say, how would I steal the gun from you when I put it, when it was in your hand?
Let me stop you there. The day he came and retrieved his weapon,
Uh-huh,
there was some kind of SUV parked in front of your residence
correct.
that contained Mr. Brown's possession.
Yes.
How long after he retrieved his weapon was this vehicle parked in front of the residence?
Objection, Your Honor.
At least,
Wait, pause, there's an objection. You can articulate the reason why you feel it's not relevant.
That has absolutely nothing to do with what the complaint is.
Well, I have a question on the side of my notes for a time frame. So let's get that answer first.
Okay,
So you claim that Mr. Brown was in the hospital, you took him there.
Yes,
Then he called you, but then he called you back and someone picked him up.
yes,
You took possession of the house allegedly February 1, but Mr. Brown was still coming and going.
yes.
The hospital incident, give me an approximate date and time,
It's within the first 2 weeks of February.
within 2 weeks of
Yeah.
February.
Yes,
And then the issue with the duffel bag and the alleged retrieval of the AR-15, what is that time
this is
frame?
all within the same 2 weeks.
And now we're to the objection. After the AR-15 is allegedly picked up, you said, how long did the car remain in front of the house?
Okay, from the day that Mr. Brown picked up his weapon, the car stayed there for over 2 weeks.
Okay, pause. That's where you're
that's my
objecting.
objection.
Okay, the car remained
No,
there.
no,
for-
hold on. Let me make a ruling on the objection. Now I want to hear from you that I got the time frame in my head.
It has absolutely nothing to do with May 5th, 2020.
Judge, we're getting there.
I'm gonna overrule your objection. Court finds, we've got all this foundational issues. The court finds that it's a foundational question, overrule the objection. You can answer the question.
Thank you, Judge.
Restate it for him.
So, okay. After the AR was retrieved, how long did this SUV remain in front of your property?
Over 2 weeks.
Okay. Now, during that 2-week period, did you ever see Mr. Brown?
I did.
Did he come to your home? Did you see him
No.
outside?
I saw Mr. Brown. I owed his uncle, I owed Mr. Williamson rent money, right? I told Mr. Williamson that I would not pay him any rent money until he retrieved my contract that Daniel Brown had taken.
Okay,
And that was,
now,
okay,
let me stop you there.
Yep.
So Mr. Brown had taken something from you, and
Yes.
you were withholding rent
yes,
until you were to obtain your property back.
yes,
or-
because
right?
Mr. Williamson promised me that he would return, he would get my contract back from his nephew,
Okay. Now, let me ask you this.
from
So-
Mr. Brown.
Okay, so during that 2-week period, you did see Mr. Brown,
Yes,
and you spoke with him.
yes,
Did he ever mention this AR pistol during that 2-week period?
no,
How many times after that time frame did you see him I'm sorry, let me rephrase that question. 2 weeks has passed, and now the SUV is gone,
right.
correct? Okay. From the time the SUV moved until May 5th of 2020, how many times did you see Mr. Brown? Just approximate number. Doesn't have to
2
be
times,
exact. I'm sorry?
2 times,
2 times?
yes,
And those 2 times, did Mr. Brown ever ask you about an AR pistol?
no,
Now let's fast forward to May 5th, 2020.
I have something to interject that may be
No,
relevant to this.
no,
one.
no,
Oh,
can't
go
do
ahead,
that.
go ahead,
You gotta
continue.
wait
I
for
apologize, thank you,
questions.
Your Honor.
Hold on. Question?
Let me restate my question then. You say you observed and you spoke to Mr. Brown on 2 occasions
Yes,
after the SUV had been picked up,
correct,
and he never asked you about the AR pistol?
no,
Give me 1 second, Judge. But you did speak with him.
yeah, but not, yes.
Okay, well, was it casual conversation?
I would go to Mr. Williamson's residence. This is where Mr. Brown went to reside after he left my residence.
Okay.
I would go to Mr. Williamson's residence to talk about see if he retrieved the contract so I can pay him his rent. And that's when I would see Mr. Brown.
And did Mr. Brown observe you as well?
Yes,
But again, never approached you about the AR pistol that
Never.
was missing.
never.
Right, so let's fast forward to May 5th, 2020.
And you're
Okay.
gonna pause right here.
Yes, Judge.
If we're gonna pause and then now take probably a fair amount of testimony, I want to do a calendar conference.
That's fine, Judge.
I got a calendar conference, but we're at a break in thought here. Sir, who's in the witness room? Is there other witnesses there?
Ms. Moore,
You know what, do you mind just sitting right here?
that's fine.
Is Officer in Charge Detective Moore possibly officer.
Are they
Trevino.
officers in there?
Yes.
All right, you can go in the witness room. I just want to do a really quick case. People are waiting for us. Hold on just a second, sir. Cannot discuss the case with anyone. Don't give them your thoughts or impressions. Don't tell them the questions asked, answers given. But if they're all police officers, I'm gonna let you go in there if there's no other civilian witnesses.
Do I leave the mask here?
That's your mask. You're
Okay.
gonna take it with you when
Okay.
you walk out the door. Take it with you in the witness room. You don't have to leave. Your client can stay right there, Mr. Harris. If he wants to use the restroom, you wanna take him out in the hall, but I just wanna do a calendar conference. This is an odd time to break, but we're changing thoughts and time frames.
We're gonna go to the restroom.
You may. Okay, no problem.
It looks as though actually this is a free at a calendar conference.
Oh, okay.
Mr. Shedrow, can you stop the recording? on
Oh,
this?
I'm sorry. Let me stop the recording. I'm gonna take a break here.
Where's your client, Mr. Shedrow? Mr. Shedrow?
Mr. Shedra, you don't have your volume on.
All right, I'm sorry.
Oh
Miss-
dear. All right.
Mr. Hunter, so what you're wondering?
Yes. No,
He's
no,
in-
no. Rebecca. Oh, you gave me the wrong file.
I sure did.
Hold on
I'm so
just a
sorry.
second. Let me, I thought your case was ready and I'm trying to get you in your,
It won't be.
There you go.
all right, so let's call this and find out what's going on.
Okay.
Good, go.
The court is calling case 21-9142 in the matter of the people of the state of Michigan versus Anthony Hunter here today for calendar conference. Appearances for the record, please.
Kevin Battersby Whitnoff on behalf of the people, Your Honor, P 85532.
Sir,
Please on record George Shedro P 41732 in behalf of Mr. Anthony Hunter.
okay. What can you tell us about your client's whereabouts, Mr. Shedro?
Well, I will tell you this, on March 28th, I met with Mr. Hunter at the Wayne County Jail. Soon afterwards, and right now, he is sitting in the Macomb County Jail again. His release date is August 22nd, 2022.
Okay, hold on a second. On March 28th, you met your client at what jail, Mr. Shedro?
The Wayne County Jail, right down the street.
Got it. Okay, and then, all right, and I know he was in the Macomb County Jail in February. Do you know where he is today, sir?
He is back in the Macomb County Jail.
All right, because Mr. Bowman, who handles writting out of defendants, just told me that he is no longer in the Wayne County Jail, which you've just verified. And that's where our last writ went to. So we do
And-
not have a client here today.
Obviously, in there, on the, what I could understand, they're waiting for a writ to be, send him back to you guys.
Well, I can't speak for somebody else, Mr. Shedro, other than the fact it execute a writ, but we executed a writ at the wrong jail. Mr. Shedro, I don't have notes on this, but I have a similar case where I struggled getting a defendant here because he's wearing two wristbands with the same name and two different birth dates, his and his brother's.
Correct,
that-
that's him.
Is that this client?
Yes, and now he has a third name.
Oh dear.
So good luck.
Okay, so my memory is this client because he stood here in front of me, wristbands on, and I made one of my sheriffs read the wristbands to me. And there was two different birth dates. He's in two different county jails on two different birth dates, one of them being his brother's.
Correct.
And now you're telling me there's a third wristband, Wayne County, Oakland County, and Macomb County? How am I doing? Is that accurate?
The Macomb County has him on the third name. I didn't write it down. Ferguson
right.
is all I could tell you.
All right, well, we have a pretrial investigation DSU summary that lists Anthony Van Hunter, Wayne Frederick Hunter, Anthony Hunter, and now you're telling me there's a third name?
Might be Frederick.
Right, because we've got Frederick Hunter in one
Okay.
of the AKAs, but it's Dwayne Frederick Hunter.
Right.
Oh dear. Do you know how long what's next? Wayne County, Macomb County, or what's happening next in Macomb County?
He has been sentenced and his earliest release date is August 22nd.
What's happening in Oakland County?
I don't have anything in Oakland County. I don't know anything about Oakland County.
Oh, I thought you said that there was a third wristband.
Oh, no. Their name. But you have that. If I misspoke, and I apologize.
No, I'm just trying to follow I'm just trying to get it back.
Understand?
Enough questions to be successful in getting him here. That's all I'm trying to do. He's under sentence in Macomb County at least until August, correct?
Correct. That's correct. On 3 different cases.
Are they all resolved in one package and that will keep him, or does he have outstanding matters?
Seems to be resolved, Your Honor. The numbers are consecutive in the cases, so probably was packaged as a deal. Because they all list the same out date.
All right, fair enough. So you've told me enough to allow for conclusion that he's gonna stay in Macomb County until somebody brings him to us. And I suspect that it would be in his best interest to be brought here to address this matter. And if convicted or pled to something here, so there could be some type of concurrent sentencing, not suggesting he isn't presumed innocent and this may go to trial, but I somewhat suspect that you'd like to get this resolved.
Well, I believe that there has been no offer made because of his lengthy record. And if I misspeak on this, forgive me, but I believe you said go to the gun board, but with his lengthy record and your prosecutor, courtroom prosecutor, I believe I don't know what his name is, they would not give him gun board.
Well, he is facing a 7-count felony information in front of me. The charged felony firearms, 3 of them, include a third or subsequent offense notice allowing, requiring, if convicted, a 10-year flat consecutive sentence. And there's a habitual 4th. But I'm never going to tell anybody not to write a letter to the gun board, but if
Not
we
wasting my
receive
time.
information that they are not making any consideration or it won't be considered, I'm leaving that between you and the prosecution. I would also note that the DSU in front of this court spans 2 half pages of prior.
I'm sorry.
Well, I'm trying to decide. One's a little less than a half page and one's a little more than a half page. I'm gonna go get a date from Mr. Bowman and bring him here. Mr. Shedro, I am gonna require that you're in person since he's gonna be in person. Is there a day that you're already scheduled in person at Frank Murphy Hall of Justice so you can handle both matters?
Let me look, Your Honor, but I was on my way to your courthouse when your administrative assistant called me and said, we don't have him.
Well, I thank you for the efficiency of my staff to call you off. Tell me a day that you're here and I'll try to make sure that you're in here for more than one case.
How much time do you need?
Hold on just a second. Mr. Bowman's asking me a question. Will Macomb County set up a video Oh, Macomb County will set up a video. If he's on video, I can at least put the two of you in a breakout room.
Oh, that'd be fine. We could
All
do
right,
that.
so it appears to me that Mr. Bowman is gonna video him here versus transfer him. So, Mr. Bowman, could you give us the next date, please? Because obviously this is gonna take a couple weeks to set up. But do you have any objection if it's done by video from the Macomb County Jail, Mr. Shedrow?
I think that avoids a lot of confusion and makes it a lot easier.
Oh, here's my notes. I do have notes on this. He's under Dwayne Hunter with his brother's birthday. And he's wearing two wristbands, one in Wayne County, one in Macomb. And he's here under Anthony Hunter in Macomb, under Dwayne Hunter. So he's got two names, two birthdays. That's a problem. The court's gonna find that the fact that he's not here today is attributable to the defendant himself, sir. May 20th, 1 o'clock. Does that work in your calendar, Mr. Shedrow?
The 20th. Oh, no, that I'm gone that whole week.
That was a no. He's gone that whole week, Mr. Bowman. Mr. Shedrow, I do have a new prosecutor. I'm gonna say his name. I think I speak a little louder. Kevin Battersby Wittenoff, Wittenoff. Mr. Wittenoff, is there an offer that the people would like to place on the record so Mr. Shedrow can speak to the defendant about it?
Not at this time, Your Honor. My docket attorney is currently speaking with the gun board. I don't have any information to relate to the court or defense counsel.
And for your information, Mr. Shedrow, we're getting Mr. Surma back as the docket attorney. I think that might already be effective, just to let you
Okay.
know what the chain of command is. Let me get a new date from Mr. Bowman for you. And I'm going back to the trial.
Just
Mr.
real,
Bowman,
Mr. Whitnoff?
May 26th at 1:30, Mr. Shedrow.
Yes, I can do it.
All right, that's the next date. Did you have a question for the prosecutor?
No.
Mr.
I was just gonna ask him to email me so I have his phone and address.
I'm
Thank
sure
you.
All right, we'll see you at May 26th, Zoom hearing, defendant from the Macomb County Jail. Plea of not guilty will continue. Anything else you need to place on the record, Mr. Shedrow?
Nothing in my behalf.
Prosecution?
No, Your Honor, thank you.
That completes this hearing off the record.
Thank you, everybody. Have a good day.
All right, who's this other attorney that is here?
It's a plea and the defense is here as well.
I'm not doing a plea during the middle of testimony.
What time do you want them to come back?
Counsel, can I get you and your client to come back? Let me see the file, please. And then we have that other case at one, the press case, and then we have done with this, right? All right, let's take this while we're here. All right, counsel, just sit a minute. Let me take this plea and. then
Thank
I'll
you.
literally stay.
Can I go do another Zoom?
Yes, go do another Zoom. Let's just get rid of this trivia, not trivia, I apologize, but I want to get to the of the nut here.
Can I?
Are we ready?
Yes, Judge.
Okay, go ahead.
Court is calling case 21-8778 in the matter of the people of the state of Michigan versus Rebecca Gagnon here today for calendar conference. Appearances for the record, please.
Kevin Wittenoff on behalf of the people, Your Honor, P85532.
And good morning, Your Honor. Brendan Dabalski appearing on behalf of my client, Rebecca Gagnon. She's present on Zoom. Ms. Gagnon, state your name and that you have no objection handling this matter over Zoom today.
Rebecca Gagnon, and yeah, I have no objection.
Gagnon, I'm gonna place you under oath to take that answer. Would you kindly raise your right arm? Do you solemnly swear to tell the whole truth, nothing but the truth, so help you God?
Yes.
All right, Miss, and pronounce your last name for me, ma'am.
It's Ganyu.
All right, Ms. Ganyu, you have an absolute right to be present in my courtroom for the hearings. It is also A-OK, legally okay for us to handle this on Zoom technology. As your attorney stated, is it okay that you're proceeding on Zoom?
Yes, Your Honor.
Okay. The court is in receipt of a settlement offer and notice of acceptance. It bears the signature of all three parties before the court. Actually, it's signed by docket attorney, Mr. Surma. Mr. Prosecutor, if you would kindly present the offer for the record.
Yes, Your Honor. The people offer a charge reduction to only count 2, assault and battery, and count 4, reckless use of a firearm. The terms and agreements of this settlement offer are probation for 2 years. The defendant is not to have contact with Tyler Bowles, Blake Martin, or Melanie Bowles. The defendant is entitled to alcohol and mental health assessment with treatment if necessary. The defendant is to forfeit the weapons to the Taylor Police Department, and the defendant is not to have any firearms in possession during the period of probation, as well as any terms and conditions set by this court.
And I would like to restate this for a moment, Mr. Whitnoff. Count 2 is a charge reduction from felonious assault, a 4-year statutory maximum penalty, to assault and battery, a 93-day misdemeanor. And then she would plead guilty as charged to the reckless use of a firearm, a 90-day misdemeanor. The people then would be dismissing counts 1, 3, and 5, correct?
That's correct. Thank you for the clarification.
All right. Is that your understanding of the agreement, counsel?
Yes, Your Honor.
And Mr. Dabolsky, does your client wish to avail herself of that offer?
She does.
All right, Ms. Gagnon, I'm going to ask you a series of questions. I'm going to give you a friendly reminder that you're still under oath. Ms. Gagnon, tell me your name.
Rebecca Ganyu,
Ganyu, excuse me, your age,
24.
and you're a United States citizen, correct?
Yes, Your Honor.
Do you understand the offer that you're pleading to count 2 a reduced charge of assault and battery, which carries a statutory maximum penalty of 93 days? And you're pleading as charged to the reckless use of a firearm, count 4, which is a 90-day misdemeanor. And the balance of charges are being dismissed with the recommendations to the court that were just outlined. Is that your understanding as well?
Yes, Your Honor.
Under the influence at this very moment of any drugs, alcohol, or mind-altering substances that would interfere with your ability to engage in this court proceeding today?
No, Your Honor.
Do you read and write the English language?
Yes, Your Honor.
Okay. Have you had sufficient time to discuss this with your attorney?
Yes.
Had sufficient time to think about it?
Yes, Your Honor.
And are you freely and voluntarily accepting the offer as outlined?
Yes, Your Honor.
Is there anybody forcing, threatening you, or twisting your arm to get you to plead guilty?
No, Your Honor.
Other than the offer before the court, has anybody given you anything of value to entice you or lure you, given you any promises that I don't know anything about to get you to plead guilty?
No, Your Honor.
Does it make sense to you that if you plead to the reduced count 2 and count 4, the balance of charges are dismissed, that there's nothing left? So therefore, if your plea is accepted, you will not have a trial of any kind and you're giving up your trial rights. Does that make sense to you?
Yes, Your Honor.
Right, I'm going to review those rights with you that you're giving up. First and foremost, you're presumed innocent. You have an absolute right to a full trial and full hearing and to be represented by an attorney. Obviously, you've retained counsel in this matter. The prosecution has to prove beyond a reasonable doubt that anyone is guilty. They would attempt to do that by calling witnesses to the witness stand for testimony. Those witnesses would first ask the questions posed to them by the prosecution. Your attorney can question each and every one of those witnesses on your behalf. That's called cross-examination. You may call witnesses and present a defense if you choose. If you need help getting your witnesses to court, I could issue them a subpoena, which is a court order compelling their appearance to the courtroom. You have a right to remain silent. Your silence can't be used against you, and it's your choice whether or not you wish to testify in your own trial. Do you understand all of the rights that I've just given you?
Yes, Your Honor.
You also have a constitutional right to a trial by jury, 12 members of the community randomly selected to listen to the testimony and determine the facts. What the facts are determined to be is a decision for the jury. They are the fact finders. I would provide the law to the jurors to apply to those facts. The jury would then subsequently return with a verdict of guilty or not guilty. Do you understand that constitutional right as well?
Yes, Your Honor.
Giving up every one of the rights that I just said. Do you understand that?
Yes.
Do you need me to repeat any of those?
No.
And you're giving up your rights to a trial freely and voluntarily. Is that accurate?
Yes, Your Honor.
Are you on probation or parole anywhere?
No.
Do you have any criminal matters pending anywhere?
No, Your Honor.
Counsel, I'm going to rely upon those answers, not to mention she's pleading to 2 misdemeanors to conclude that consecutive sentencing doesn't need to be discussed with your client. You agree?
Yes, Your Honor.
All right. And you also pronounce your last name for me again.
It's Ganyu.
Ganyu. All right. I had my former clerk was Gagne, so I get that in my head, and I
Oh, yeah.
use the phone.
I get that.
So Ganyu, pardon me, Miss Ganyu. All right, Miss Ganyu, if you're please accepted, you have a right to appeal to the court. Because we get background, Mr. Dabalski. Okay, you
I'm
did it.
sorry, Your Honor. Somebody walked in my office.
I
Apologize.
know it. I got it. I understand. Back to you, Miss Ganyu. You're Ganyu. Pardon me. Miss Ganyu, back to you. If you have a right to appeal a plea, conviction, and sentence. Because this is a plea, it would be by application to leave to the Court of Appeals instead of the automatic right that follows a conviction at trial. Because this is a plea, you're giving up any claim that the plea was a result of promises or threats that were not disclosed to me. You've told me there was no promises or threats. You're also giving up the claim that this wasn't your own free will, free choice to plead guilty. You told us it was. Understand all of that.
Yes, Your Honor.
In addition, you're giving up any rights, appellate rights that attach to the trial because we're not having a trial. Does that make sense?
Yes,
Ms.
sure.
Ganyu? All right. Ms. Ganyu, you agreed to have this hearing on Zoom, correct?
Yes, Your Honor.
All right. If I had the pleasure of having you in this courtroom, this is the settlement offer. The settlement offer at the top of the page has identifying information such as your name and the case name. The next box indicates the charge reduction, the 2 misdemeanor counts that you're pleading guilty to, prosecution's dismissing charges 1, 3, and 5, the probationary term that you've agreed to, and then the docket attorney signed it. On the lower third is typed out all of the constitutional rights that I've already given you. And then there are 2 lines, one for your attorney. I presume that this is his signature, and then your signature line. Did you personally sign it, perhaps go to Mr. Dabalski's office, or did you give him permission to sign on your behalf?
I personally signed it, Your Honor.
Okay, fair enough. So you looked it over before you signed it?
Yes.
All right. Do you have any questions for me at all?
No, Your Honor.
And do you still want to proceed in the manner and fashion that we just discussed, that you are freely and voluntarily accepting this offer? Is that true?
Yes, Your Honor.
Okay. Counsel, either one of you could establish the factual basis, your choice.
Your Honor, I'll defer to defense counsel as the defendant may be able to better hear him since he's also on it.
Okay, go ahead, Mr. Dabalski.
Okay. Ms. Ganyu, please draw your attention back to October 21st, 2021. At that time, were you in the city of Taylor, County of Wayne?
Yes.
Okay. And at that time, did you assault an individual by the name of Blake Martin?
Yes.
And you did that by hitting him?
Yes.
Okay. And did you have permission to do that?
No.
Okay. And then at that same date, on that same date and time, did you have a weapon in your possession?
Yeah.
Okay, and did you discharge that weapon into the ground?
Yes.
Okay, and did you have any type of permission to do that?
No.
Okay. And you, and on both counts, you intentionally did that, correct?
Yes.
Okay. Your Honor, I think the elements are satisfied, at least according to the defense.
I want to clarify the place of the location.
Oh, I'm sorry. That would be at 6704 Pine Street in Taylor, Michigan.
Is that correct, ma'am?
Yes, Your Honor.
That's at your residence?
Yes.
All right, I overspoke over you on the last question. What did you say about residence? Whose residence is that?
Ms.
Mine.
Gunn? Oh, sorry.
Who lives at 6704 Pine Street in Taylor?
I do.
And this happened in front of the home, thereabouts, backyard?
It happened in my front yard.
Okay, fair enough. Now, counsel, the stenographer asked me to ask you to repeat something that you said about 3 or 4 questions ago. It had to do with this, that the defense is satisfied that the material elements had been satisfied, at least from, and then she lost it. At least from your perspective, is that what you're saying, counsel?
Correct, Your Honor.
Okay, his audio, see, it went in and out when he said that portion.
That would be correct, Your Honor. I'm sorry. Is that better?
Yeah, sometimes we just missed a couple words, but I think that we've covered the question. I want to ask Mr. Prosecutor if he has any additional questions regarding the elements.
Just one, Your Honor. Ms. Gagnon, the aforementioned weapon firearm that was used during this incident, that was a handgun, correct?
Yes.
Thank you.
Okay.
Sure.
Counsel, both satisfied with both a factual basis as well as court's compliance with the court rules. Mr. Prosecutor?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Court is satisfied that this is a knowing, intelligent, and voluntary admission from Ms. Gagnon, and the court is satisfied that the material elements to support the conviction of assault and battery, reduced charge on count 2, and reckless use of a firearm have been satisfied on count 4. Find her guilty of same. Mr. and defense counsel, I'm sorry. I am not doing immediate sentencing. A, I'm in the middle of a trial. Secondly, the court wants to know more about Ms. Gagnon so the court can have an appropriate rehabilitative sentencing. Ms. Gagnon, do you have a pen and paper in front of you?
I can grab one.
All right, or I can give the phone number to your attorney and he can convey it to you by email, texting, or calling you. The phone
Okay.
number is 1-3-224-2600. Repeating 313-224-2600. My staff needs about an hour to get that information over to that department. Then your name will go on a list. You're going to call that number and introduce yourself. Tell them that you just pled guilty. They're going to make appointments with you to complete what is called a sentence, pre-sentence investigation report. And then we're going to come into the courtroom for sentencing. And so don't forget to make that call. Start at about 1:30 today to 4, no later than noon. Counsel, given her young age and the seriousness of this, the court's going to require that sentencing is in person at Frank Murphy Hall of Justice, but I am happy to accommodate your schedule, counsel. I am looking at the 1st of June. Let me get a date from my staff.
Mr. Dabowski.
Yes,
Mr. Dabowski. Hi, this is the court reporter talking to you. What's your P number, sir?
70713.
Thank you.
You're welcome. Your Honor, I know she's looking for a date, but if possible, Friday, May 3rd would work for me.
What would Friday, what?
Or excuse me, Friday, June 3rd. I said May, I
think-
meant June.
Yeah, I think we're tapped out that day. Hold on.
Okay.
Third weekend anymore. Council, we are booked solid on June 3rd. I'm gonna go into the next week. Do you have a preferred date, council?
Preferably the 10th of June. It's a Friday.
I think we can do that. Can we do June 10th, Mr. Bowman? 1 o'clock, June 10th. Can you make that work, council?
1 o'clock, absolutely.
All right, that's your next day. Miss Gagne, no, that's my other staff's name. Gagne, pardon me. Miss Gagne, I am requiring you to come into the courtroom. I
Okay.
think it will find it beneficial. Don't forget to make that phone call. Mr. Prosecutor, I also want to know if there are individuals that will be coming into the courtroom or speaking pursuant to victims' crime rights. Please be mindful, you need to give their names to Mr. Bowman so that they can enter in the building if they choose. They are also welcome to make a victim's impact statement if they choose on Zoom technology. If they're gonna come in, we need to know in advance, so there's an admission ticket at the door for them, for lack of better words. If there are victim statements, I want to know in advance. I don't want to keep victims waiting. We're going to call the case on time. And so be mindful of that, everybody, and please let defense counsel know that they are coming.
Yes, Your Honor.
Miss Gagne. I always want to say to individuals who take ownership about their behavior that I respect the fact that you took ownership and pled guilty to that. Every one of us needs some self-improvement in our lives, myself included. But to improve, Ms. Gagne, we need to make an admission as to the area where we need improvement. So I certainly want to commend you for taking ownership. This has been pending for some time. And thank you for your honesty and taking ownership here today. I'll see you at 1 o'clock on June 10. Is there anything else that council needs to place on the record?
No, Your Honor.
All right, that completes this hearing. Don't forget to make that phone call. Madam Clerk, do you need the address or phone number? Or you're all set. You're already ahead of the game. Thank you.
Thank you, Your Honor. Have a great day.
Okay. Where'd everybody go? Sorry about the delay. Is Mr. Harrison here? Let's see where he is on another case. I'm ready for you when you are. Okay. I think he's engaged in another case. On the record in the matter of the people of the state of Michigan versus Daniel Brown, I apologize for the interruption for both the court and council to conduct other business and concerning other matters. I'm noting for the record that prosecutor Wittenoff, Andrea, Mr. Harris, defense counsel, Mr. Brown are all present in the courtroom, and the witness is back on the witness stand. Both parties prepared to proceed?
Yes, Judge.
Yes, sure.
All right, and so, Mr. Andre, obviously you were asking questions, and I apologize to you, Mr. Herndon, as well as to you, Mr. Brown, for just the necessity to address other matters. Go ahead, sir, next question.
Thank you, Judge. Mr. Herndon, before you took that brief pause, we were discussing the date of May 5th, 2020.
Okay.
Okay, so we discussed this a little bit before, you were at home?
Yes.
Okay,
Excuse me.
no worries. All right, let's just go back to May 5th. Start from the top, you were at home,
Yes.
okay,
Excuse me.
and you heard some commotion outside.
Correct.
All right, you came outside.
Yes.
Who'd you see again?
Daniel Brown.
That's the defendant sitting right here to my left, right?
Correct.
Or you're right.
Yes.
And would you hear he was disgruntled?
Yes.
What did you hear him saying?
Ain't nobody gonna take nothing from me and get away with it.
And at the time, did you know what he was referring to? At the time when you heard him?
Not directly.
Okay.
Not directly.
What do you mean by that?
He had never directly himself told me that he had accused me of taking a weapon. However, I had heard through other people that
Objection.
Mr.
Don't
Brown,
Yes,
answer
sir.
the question, there's an objection, hearsay, sustained.
Yes.
it was revealed.
One second.
No,
let me
just,
ask
he's
you a
gotta
question.
ask you a
Okay.
different question, sir.
Okay, so you received some information from other folks
Yes.
that led you to believe that what Mr. Brown was disgruntled about was you taking his weapon.
Yes.
Okay. So now you hear Mr. Brown disgruntled, yelling obscenities.
Yes.
What was he saying exactly?
He know what he did. Ain't nobody gonna take nothing from me and get away with it.
And where was he at this point? Where was he standing?
He was not standing. He was seated inside of the vehicle with the driver's side door ajar in the driveway of the house next door.
So in the vehicle, he was seated on the driver's side or passenger side?
Driver's side.
Was anyone else in the vehicle?
No.
And at this point, where are you seated, standing? Where are you?
I am standing on the stairs of the house next door.
And this is your residence?
Yes.
And about approximately how far is the vehicle that Mr. Brown is sitting in relation to where you're standing?
15 yards.
15 yards. Okay. Again, you hear everything pretty clearly.
Yes.
So what happens next?
When I come out and see what's going on, there's a neighbor who's there that he's speaking with. She waves to me like this. Come here.
Okay.
Her name is
For the record,
Go ahead.
for the record, let's describe what he did.
I think so too. Do it again, sir. I saw it, but
All right. So for the record,
she's on her porch, he's in her driveway. She sees me on my porch. She motions me to like this.
okay,
So-
just pause for a second. Let us describe. Go ahead, counsel.
Your Honor, for the record, the witness has his right hand up, making a waving motion as if to say, come over here.
Okay.
Mr. Harris agreed with the description,
Yes, sure.
and I believe that it also would go to state that all of us would agree that the waving motion was her outstretching her hand, bringing it towards her body in a motion that would indicate to come on over.
That's correct, Judge.
So
I agree.
reflect. Next question.
Okay, so she waves you over. Do you go over there?
I'll walk across my driveway onto her front lawn.
Okay, so approximately You're standing on front lawn, approximately how far is Mr. Brown from you?
I closed the distance, now there's maybe 8 yards between us.
Okay, 8 yards.
Yes.
Okay.
Now,
Wait for
one
the
second.
question, hold on.
And then what are you observing at this point?
I'm observing Mr. Brown sitting in the vehicle. He's disgruntled. And Nina, we call her Nene. This is the woman whose house he's at. Nene says to me,
Do you know her real name?
I do, Deborah.
Okay. Do you know her last name by chance?
I do not.
Okay, okay. But you call her the nickname.
Yeah, I call her Nene.
Okay.
She said, she trying to get an understanding of what's going on. She said, Daniel said you took a gun from him.
Objection, here, sir.
If you can't tell us what someone else is saying,
Okay.
I'm gonna sustain the
Okay,
objection. Just slow down, wait for the question, no narrative, remember?
Right, so she's present while you and Daniel are present,
Yes,
and she's trying to get an understanding of what's going on with the situation.
correct.
So she says something to you, which leads you to believe now that Mr. Brown is angry about this gun.
Correct.
Okay. What is Mr. Brown saying?
He know what he did. Ain't nobody gonna take nothing from me and get away with it. They gonna have to move out the house. We gonna deal with this. They better get out of there.
All right, and at this point, he's seated in the vehicle.
Correct.
And this is that gray Hyundai, silver Hyundai?
Correct.
Does he remain seated inside the vehicle for the duration?
Yes.
So he never gets out of the vehicle?
No.
So he,
You all right?
Okay, I got it, okay, just give Mr. Brown a moment.
Off the record, Judge?
Off the record. Do you want a basket perhaps? Mr. Brown, go back on the record.
I was wondering if you needed.
I'm gonna get there, just go back on the record. Mr. Brown, I know that you were kind of in a deep cough. Would you like to stand, take a walk? Would that help? Mr. Harris, come up and get this box of Kleenex from me. Does he need more water?
You need some water, Mr. Brown? No, ma'am, I had dialysis earlier this morning.
I'm, okay, noted for the record. There's a Kleenex, we got a little basket there. Would it help to stand? Okay, just, okay, you can do whatever you need to do. Have you caught your breath, Mr. Brown, or do you need a moment?
Yes, ma'am, I'm here.
Okay. All right, so let us know how we can accommodate you. All right. Okay, Mr. Harris,
Judge Good.
you know, I that giant fan was brought in by me. You know how hot this building gets sometimes. You're fine, because you want me to see if I can move the fan there?
It's all right.
Okay, I'm just offering thoughts, Mr. Harris. If he wants a fan on, we can move it and place it.
We'll make a decision. I'll just raise my hand,
Let me know.
let you know.
Okay,
Thank you.
so pause for the next question. Back to you. I'd like you to repeat the last question.
So, Mr. Herndon, just to clarify, Mr. Brown is seated inside the vehicle,
Correct.
and he's seated inside the vehicle for the duration of this incident?
Yes.
All right, just to be clear, he never gets out of the vehicle.
Correct.
happened next?
I'm speaking with the neighbor. And
This
she's
is,
Deborah, with Deborah.
Okay.
She's saying she's saying.
Okay, well, remember, you can't tell us.
She said that,
Hold on, be
Okay.
careful, wait for the question.
Okay.
Remember, you can't tell us anything that Ms. Deborah said.
Okay,
Only anything Mr. Brown said or whatever you heard.
okay.
So, all right, so you're listening to all this information, you realize he's talking about this AR pistol.
Mhm.
Does he say anything directly to you?
Yes.
What does he say to you?
He say, I asked him a question. I asked him, I said, what makes you think I took your gun when you took it away from here with you?
And what does he respond?
His response was, you know what you did.
Now, did Mr. Brown appear intoxicated or anything like that, that you can tell, that you observe?
Marijuana.
Have you ever seen Mr. Brown smoke marijuana?
Yes.
I apologize. I did not get the last. I got the last question. Have you ever seen Mr. Brown smoke marijuana? And his answer was yes. What was the question just before?
I asked him if he observed, well, okay. I asked him, did Mr. Brown appear? Well, I don't remember the exact phrase.
Do you want it played back?
I can repeat it.
Wait a minute.
Wait, hold on. How would you like that handled? Because Madam Clerk can play it back.
Could
Madam
you-
Stenographer, excuse me.
Could she play it back just briefly?
All right, then let her pause. She's got to get to that place. I'm going to turn off the court's recording as well. Okay, hold on, and then let us know when you get there.
Okay, now, did Mr.
Okay,
Brown
hold on.
appear?
I'm just going to put us back on.
Ready?
Go ahead.
Hold on, I gotta get there now. Okay, here we go. Now, this is the APA. Did Mr. Brown appear intoxicated or anything like that, that you could tell that you observed? Answer, marijuana. Question, have you ever seen Mr. Brown smoke marijuana? Answer, yes.
Okay, I believe that your
I
question.
apologize. Okay, stop.
Okay, stop.
Okay.
I believe that was the question that you wanted, Mr. Harris. Does that complete?
We're off the record at this moment. At right now, while you're talking.
I'm taping it, but we can summarize it when you get back on the. Do you need anything else, Mr. Harris?
Yes. No, I don't. I got the answer.
Okay, then let her get back to the place where she needs to get on her recording.
Okay, we're on the record now.
Okay, she's back on the record, but for the record, Mr. Harris, obviously, Madam Recorder played back, orally gave the question and answer. Did you get what you were seeking?
Yes, sure.
All right, then let's pick up with the next question from the prosecutor.
Thank you, Judge. So let me ask you this. So is it your testimony that you believe Mr. Brown may have consumed marijuana?
Yes.
Okay. All right, so now again, you're standing outside of the vehicle. How close are you to the vehicle now at this point?
Still 8 to 10 yards. I came from my porch across the driveway to the middle of the yard.
Right.
I never came much more than a step or two more closer to Mr. Daniel.
Okay, so you were never in close proximity to Mr. Brown or the vehicle.
Not no closer than 8 to 10 yards.
Okay, now, you sitting in the witness stand and me being here,
That's about the distance.
about the distance.
Maybe a step or two short.
John, I'd say it's about,
10 yards.
I wouldn't even say 10 yards, I'd say it's about 6 to 7 yards.
Hold on, the distance between the witness and you?
Correct.
Okay, you guys are in yards now, so 6 yards, or 6 yards would be 18 feet.
It may not even be that much.
A yard is 3 feet.
Well, you know what, I used to have on this bench measurements all over this courtroom, and I don't know where it has gone in the last 2
A
years.
yard is 3 feet. And we got 10 of those, that's 300 feet, right?
Not 300,
Or what, 30, I'm sorry.
30.
Right.
Judge, let me come around the podium.
Where did that go? Where did the plastic go? I'm just
Right,
noticing
there we go.
something missing on the bench. There used to be a
Count your
plastic
feet.
cover and yard.
Yeah, we staying on the record because you keep.
All right, you
talking.
can't talk. Okay. Go ahead and pace it out if that's what you'd like to do.
I'm gonna do this in feet, clearly.
Feet, go ahead.
Yeah. That's about 12 feet.
You okay with that?
That's 3 yards.
Okay, so there.
No, 4 yards. 3, 6, 9, 12. Let's get everybody's math correct.
Right, thank
I have no objection to the identification that the distance from the front of the
Podium.
podium to witness stand is 4 feet.
On or about, the court will so note.
So you're indicating this is how far you were from Mr. Brown in the vehicle?
Right, we've been on the other side of the podium, yes.
The other side of the podium? All right, so he's suggesting it's slightly longer.
We're on the far side of the podium.
All right. Would you agree you can see pretty well that far?
Yes,
You can see Mr. Brown seated inside the vehicle,
yes,
and he's disgruntled, is he screaming at you directly?
yes. Once I asked him the question, when I began to, when Deborah motioned me to come there, I didn't walk to her stairs because I had to bring me very close to Danny. So I stopped at a safe point where I could, because Deborah was on her porch. So I could speak to Deborah on her porch, not come too close to him, right? And still be able to hear him and see him, and for Deborah to be able to try to figure out what's going on, because she was upset that Mr. Brown was at her house and she's trying to understand what the conflict is.
Okay, let me ask you this. Is there a reason why you didn't want to approach Mr. Brown any closer than you were?
Because I know he keeps guns with him all the time. And if he's upset, and I know that he's making threats, I don't want to get too close to him, but I also want to communicate with him in a way to say, hey, man, I didn't take anything from you, so why are you upset? If you tell me why you think I took something from you.
Okay, now, he answered your question, correct?
He said, you know what you did.
How did you respond?
I didn't say anything.
Okay. What was he doing while he was saying, you know what you did? What was he doing inside the vehicle?
Sitting, and he had one hand concealed. He had his right hand concealed
Concealed where?
on his, like, at his leg.
So he's almost sitting on top of his hand.
Right,
inside the
he's
vehicle.
sitting in the car. The door's open. I believe his foot is out.
So his foot is outside of the open vehicle door.
Yes. The other foot is inside.
And this is the driver's side door.
Yes.
Okay,
I cannot see his right hand. I can't see his left hand.
okay.
Okay, so let the record reflect, please, sir, hold your hand, hold the position just the way you were. Could you please hold the position?
Go back to, you were kind of outstretched on
Okay,
the
he's
chair.
like this.
Okay, so do we have a description of how he says Mr. Brown's position?
I think he's seated in a vehicle with his leg outstretched outside of the driver door.
His left leg
His right hand is out of is out of sight.
His right hand.
It's down along.
Mr. Hernan,
I apologize, okay.
his right hand, Your Honor, the witness's right hand is down next to his right leg, by his knee.
And you were in a fist position, is that correct, with your right hand?
My right hand?
When you just sat there, your hand was in a fist position, your right hand, is
Okay.
that correct?
I don't know. I wasn't conscious of the position in which my hand was.
But you're not saying that Mr. Brown had a fist clench. You're not saying
I
that.
am not.
Okay. Because
But just let Mr. Harris, he said he couldn't see the right hand, correct?
Correct.
But
It was-
this witness is sitting there, positioning himself, and his right hand is in a fist position. All
And
I'm
just-
trying to establish is the description of what this witness has done.
I had no.
All I'm trying.
Okay, but hold on just a second. And the witness also said upon response to that is he wasn't conscious of what his right hand was doing. Could you see the defendant's right hand?
I could not.
But you did make a comment, and we didn't get to what his position of his left hand was. You saw Mr. Brown's left hand.
I could see his left hand.
Are you satisfied, Mr. Harris?
I'm sorry, did he say he could see
He
his left
could.
hand? Could, okay.
I think
I'm
this,
satisfied. Your Honor.
okay, go on, next question.
so you couldn't see his right hand.
Correct.
At any point did you see his right hand?
Yes.
When did you see his right hand for the first time?
After I saw that we were accomplishing nothing, trying to communicate with Mr. Brown. Nothing was accomplished with Deborah and with her trying to figure out what the complication was.
Right.
So I just walked back across to my driveway. At this time,
You're in the midst of walking away from the
yes,
vehicle.
I turn around when I see that no communication is gonna work at this time. I walk back to my porch, and I believe Deborah,
Objection.
I apologize.
Yeah, don't tell us what you maybe
Okay.
think. It always has to be
I
what
walk-
you know.
I walked back, turned my back, walked to my residence. Mr. Brown pulled out of Deborah's driveway, and he came toward the direction of my house because he's gonna go that direction when he leaves the street.
So he pulls out of the driveway
Mhm.
and then
He bags out,
he backs out of the
Yes.
driveway and now he's driving along.
creep. He's going slow. Now I'm still outside, and he's still making threats. Yeah, y'all better get up out of there. It ain't safe for y'all to be there. Ain't nobody gonna take nothing from me and get away with it. I'll be back. This is my hood. I'm calling the snap. So
I'm
And this is-
calling the,
I'm calling some guy, I don't know the name. He's saying that the gun belonged to
okay,
someone else.
but hold on, I just had one word that I missed. That's all I want. I'm
He's calling, he mentioned the name.
Okay, got it.
Right.
Next question. Just slow down.
Okay, so now you say he's creeping along,
Right.
still yelling obscenities.
Listen to me. I very badly wanted to communicate with Mr. Brown because I wanted to clear up the misunderstanding of
Your Honor,
you.
First off, I don't think there was a question on the record.
Okay, all right. You gotta only
Okay.
answer the questions.
All right,
Sustained.
Go ahead, continue with the question.
So Mr. Brown you called it creeping along,
Yes,
yelling obscenities at you.
yes.
What's he saying to you?
You better get up out of there. I'm calling my people. Ain't nobody gonna take nothing and get away with it.
And by nothing, what did you take that? Nobody's taking nothing and get away with it. What did you take that to mean? What was
That
it?
he's saying that I took the gun from him and I'm not gonna get away with it. And he's angry because he believes I took the gun and he's gonna go get some people and come and do something. I better get out of there because it's a problem because he accused me of taking his gun.
Okay. Now, during this time, is he stopped or he's still creeping along?
He stopped for a moment,
Okay.
right?
And as he was yelling obscenities at you, what else was he doing?
Looking at me,
Let the record reflect that the witness has his left hand outstretched, holding the top of the steering wheel at 12 o'clock
Well, he didn't say that. You're assuming that.
Well, that's, I'm demonstrating what I saw without saying. This,
And what is your hand holding?
my hand is on the steering wheel.
Okay, go on.
Okay, hand on the steering wheel. He's looking at me. I'm starting to approach him now, because now I'm like,
Okay, don't get going. He just described his hand is outstretched in a motion that would be
Clutching the steering wheel.
right.
clutching the steering wheel.
with
Next
his-
question.
With his left hand,
And I would also note that his head is turned right.
correct.
And what was Mr. Brown's head facing?
Me,
Okay, so he's looking directly at you.
yes.
Where's his right hand at this point?
His right hand is still along his right
And
leg.
but you can't see his right hand.
At this time, I cannot.
Okay. What happens next?
He came to a brief pause, and he's saying these people, you better get out of there. It ain't safe for you over here, this and that. So as I want to walk to this, I'm about to walk to the sidewalk so I can talk to him more. And his right hand came up.
What, if anything, did you observe at that point?
A black pistol.
So your testimony is that Mr. Brown was holding a black pistol
Yes. In
Where
his
was
right
it?
hand.
in his right hand.
Correct.
And what was he doing with the pistol?
He just brought he brought it up, and it was into view. After it became into view, I turned around and went in the house.
Okay. What did he do with the pistol? When the pistol came, strike that. When the pistol came into view, what did he do with that pistol?
I don't know. Because as soon as the pistol came into view, I did an about face.
Did you see the pistol?
Yes.
Where was it pointed at?
He didn't point it. Well, it was facing forward. He didn't point it at me. It was in his hand facing in the direction he was sitting.
Okay.
Forward like that.
Was he holding it still? Was it moving around? When it's up, when you can see it.
No, I never seen it come up. What I seen is this. I'm approaching this car because he's in front of the house. He's yapping at me. I take steps to the car because I'm gonna come closer to him so I could talk to him. That's when the gun came into view. From the whole time that his hand was concealed, I imagined that he had a weapon there, right? So I said, okay. But then when I approached the car and he upped it and he put his hand up, then there was a weapon there. And then I
Okay.
turned around from right there.
All right, so let's stop here. You said it was a weapon. What kind of weapon was it?
A black handgun.
And do you recall what type of handgun it was? If you know.
A small one.
You know the make, the model?
I do not. I've always known him.
Let me
No,
stop.
no, that's
I-
not the
I-
question.
I
Do you know the
apologize.
maker model? The answer was no.
The answer is I do not.
Okay. Did there come a time when you knew what kind of weapon it was that you picked up in the vehicle?
No,
Okay, I'm gonna stop you.
okay,
Let me ask you this. Did you ever talk to the police?
yes,
Did you ever speak with a detective, Nicole Moore?
yes,
Did you give her a statement?
yes,
Do you recall the statement you made about the weapon?
yes.
What was that statement?
That was a 40 caliber.
Okay. And that's what you told the officer, the detective?
Yes,
That was a 40 caliber?
yes. I believe, as far as I can recollect, yes. That's what it appeared, that's what it looked like to me.
All right, so let's back up here. So he's got the gun up. You finally see it come into view.
Mhm.
Means,
Yes,
Is his hand steady? Is it waving around? What's he doing with the gun in the air?
it wasn't in the air.
But you said it came into view.
It came into view.
You can see it.
Yes.
He's
Okay,
holding it up, right?
Let me imagine this. This is the street.
Let the record reflect.
The car.
hold on, let him finish it.
Okay,
Go on.
go ahead, sir.
This is my sidewalk, my front of my house.
Okay.
This is the street. He's in this vehicle, facing this way. I'm here. As I'm approaching this car, because it's in front of the house, he's sitting in his car. hand on the steering wheel. When I'm elevated because I'm standing up, he's sitting in the car. When I approach, get closer, his hand, he's sitting in the car, his hand comes up, and I can see the pistol in view. Just
Let the record reflect what the witness just described. That he placed his right hand on his thigh. Is that what you just did?
yes,
And you, when you placed your right hand on your thigh, you're indicating that Mr. Brown had a gun in his hand,
yes,
correct?
correct.
Thank you. I hope that accurately describes what he just did.
It does.
Yes, that's, I agree. People concur. Right. So he places his right hand that's holding a pistol on his lap. Prior to placing it on his lap, when it first came up, before placing it on his lap, was he doing anything with his hand while he's holding a pistol?
No,
Okay.
but I don't recall. As soon as I saw the weapon, I turned around. I came into my view. I didn't watch what he was doing with it. I seen it. I turned around and I don't know what else he did with it
Why did you do that?
because I didn't want him to shoot at me. But when I seen the weapon, I'm like, it's time to turn around. Don't go try to talk to him.
Would you say you feared for your life?
Yes,
Okay, so let me ask you this. You say you did an about face,
yes,
and then you went inside the house?
yes.
Just give me 1 second.
No problem.
When he put the gun on his lap, before you did the about face, was he saying anything? Did he say anything to you?
Yeah, he was saying, you better get up out of here. It ain't safe around here and all kind of stuff like that. So this is my hood and he was saying, yeah, stuff like that.
So he's yelling all these, he's yelling at you,
Yes, out of the car.
and at that same time, he's raising this gun to put on his lap.
As I'm approaching.
Yeah.
Yes.
But as you're approaching, he's yelling these, get out of the hood, it's not safe for you.
Right.
That's what he's doing.
Right.
Okay. And so you said you saw the weapon, did an about face, and headed inside.
Correct.
Tell us again why you did that.
Because I was afraid for my life. When he already making threats, and when I saw that a weapon was present, I felt threatened by that. Make threats. I know that you have this rifle because it was given to you, and you're saying that I took it. I don't have it, so I believe that you have it. And you're trying to make a false fight. You're threatening me. You'll come over here and use that rifle when nobody lives in the house with me and my kids.
But,
5 of my children.
but for the record, the weapon he had with him was a handgun.
Correct.
Okay. Now, did you think he had the ability to shoot you from the
Yes.
vehicle?
Yes.
And again, that's why you turned around and went inside.
Yes.
And now by him having a handgun on his lap and yelling these, get out of the neighborhood, it's not safe for you. You believe he may have intended to hurt you.
Objection.
Yes.
All right. Okay.
Wait, I heard the question and the answer. What's your objection?
The objection is he has to know within Mr. Brown's
It
mind.
calls for a state of mind, sustained.
Then I'm asking him what he thought, not what the defendant thought.
You
What
asked
was
him what
his
the
thinking?
defendant thought.
I'm sorry?
The question implied a state of mind of the defendant.
What he thought the defendant was thinking.
No, I didn't ask that.
All right, well then let me hear your question again. Because that's the interpretation I heard of your question. You were asking for a state of mind of the defendant. Just rephrase.
I'll rephrase the question for everyone to understand.
And I want to make sure I understand what's going on here. The screen just popped out with three people on the screen. I'm not sure who they are.
I know who they are. We have a case coming in at 1 o'clock
Okay.
and my staff, I know that there's a list of people.
Okay.
She's letting people in. The case from that hearing room has nothing to do with this case.
Thank you.
Are you gonna rephrase that question, sir?
Yes, Judge.
And while you're thinking of your next question, I just want to clarify that the screen that Mr. Harris is directing a question about is the Zoom screen in this courtroom. She's just preparing my clerk is just preparing for the next case.
You know, John, I'm just gonna withdraw that question. I think I have my answer.
Fair enough.
And so you saw the weapon, someone saying that did you feel like you could be hurt at any moment?
Yes,
Did you feel that you may be killed?
yes. Or possibly one of my children. They come shooting into the house and my children are in there.
And how old are your kids?
At the time, I had a 21-year-old residing there, my daughter, a 16-year-old, which is my son, a 13-year-old, which is my son, a 5-year-old, and a 3-year-old son.
A lot of minor children there.
Yes,
And Mr. Brown yelling these threats to you to get out of the neighborhood, get out of the neighborhood.
y'all better get out of the house and that kind of stuff.
And you took these threats, well, how did you take these threats to mean once you saw the weapon in his hand?
That he could come through shooting into the house and strike me or one of my children.
And so did you make it inside your home?
Yes,
And what did Mr. Brown do at that point?
he drove away.
And what did you do next?
I went in the house and immediately called the police.
Right, and did the police make your location?
They did.
And did you make a report?
I did.
And Mr. Brown did not come back at that time.
Not that day. He did not. He drove right past the police. As they were coming, he didn't leave the block immediately. He drove off, then he came back, and all this time waiting for the cops.
And you observed him drive
Yeah,
past the police?
the cops are coming. They turn the corner. He finally drives to the corner. And while he's waiting to make a turn on the corner, the cops turn the corner and drive right past him and come to me.
And you had given them a description of the vehicle he was driving?
I did, but they didn't understand. So when the cops get down to me, I say,
Objection.
Sustained, you can't
Okay, I apologize.
speak to what you
Okay.
think the police may or may not have understood. Again, calls for someone else's state of mind.
right,
You gave a description of the vehicle?
correct.
Okay. But he was able to drive past them.
Yes.
Now, when's the next time after this you see Mr. Brown?
I saw him several times. He continued to come to the block. He had some guy with him, that his cousin or somebody, and they would come to visit the house next door and walk back and forth and like just hang around and try to like bother me, just to be close, you know. But and so he came a few times doing that, and the
But
day
you never had any communication with him?
I would just ignore him because I knew that it was a problem when he came around. I would ignore him, but I couldn't figure out why you keep coming around here. You don't live on the street no more. If you got a conflict with me, why are you over here?
Okay, let me ask you this. I want to turn your attention to the date of June 11th,
Okay.
2020. Did you encounter Mr. Brown on that date?
Yes.
And do you recall what happened on that date?
Mr. Brown came to the location, to the neighbor's house again. He had a gentleman in the car with him.
And that's at or near 16165 Steele in the city of Detroit, county of Wayne, state of Michigan?
Yes.
Okay.
He had a gentleman with him that had been with him on like last 2 occasions he had been there. And I was told by the detective,
Objection.
excuse me,
Don't say
okay, I apologize.
So, okay, so you see Mr. Brown at that
Yes.
location again,
Could I have the date that you just used, sir?
June 11th, 2020.
Right.
So when you see him there, what do?
I called the police.
Right, did the police arrive?
Yes.
What happens after the police arrive?
The police arrived. Mr. Brown walked away from the vehicle and attempted to.
Well, just tell me what you observed.
Just
tell me
tell us
what you
what you saw.
The police came. They spoke with Mr. Brown. They put him in handcuffs.
Wait, no, hold on, no, let's go back to, you said the police came and Mr. Brown started to walk away from,
From the gray Hyundai, that was in, that he drove up in.
and this is the same Hyundai from back on May 5th.
Yes,
Okay. So, and are you outside, you inside,
I am sitting on my front porch,
Okay.
outside.
and you can see everything that's going on?
Yes, because it's a very nice day. It's a warm day, everything, we outside.
Okay, so you see the police arrive at the location.
Mhm.
What do they do once they arrive? What did
They-
you observe?
The police came, first one car pulled up and set a few houses down, another car came, and they got out, and they started watching Mr. Brown.
Objection.
Mrs. Payne, you can't say what they.
Okay, you're
did.
right. They pulled up, they walked over and approached him.
Okay.
And some officers came to me as well.
Okay, and did you speak to the officers?
Yes,
Okay. You made a report?
yes.
Okay. And then what did you observe Mr. Brown doing at this point?
He began to get upset
How so?
because he was bothered by the fact that the
Well, no,
officer-
don't tell me.
You
Yeah,
can't
I'm-
tell us, that's
One
a
second.
state of
Okay,
mind.
he said,
Okay, pause for just a second. We need to pause for a couple things.
I want to turn these on. because I
Okay,
thought- I
first
thought they
off,
were
you
off.
gotta turn off your phones. We cannot have phones binging. But it's also 1 o'clock, almost. And I have a case coming from a prison.
Okay.
I have time limits as to when I can call that case.
Okay.
So I was somewhat hoping that you would be at the conclusion of the direct, but I'm not rushing you, Mr. Andre,
almost
so
there.
don't anticipate that. Hold on. Oh, the case on the screen is communicating with my staff. They want to go in a breakout room. Put them in a breakout room. Okay, so just pause off of this record for a moment.
We're off the record right now.
We're off the record, okay. Mr. Calhoun. All right, Mr. Calhoun, there's a request that your attorneys, Mr. Middlestat, that's you. I know that's you, counsel. Say something. Can we hear you?
Yeah, I don't think you can hear us, Judge. Can you hear us?
No, I can hear you now, and there's been a
Okay.
request to go into a breakout room, but everybody has to have sound before I put you in there. Who's
Yeah.
going in the breakout room?
Do it right now.
Well, I think I don't know what you can see on your screen, but it's David Williams, Valerie Newman, and us.
All three of you want to go in the breakout room?
Yes. And we were
My
just,
staff is gonna take care of that.
It's already done.
It's open, go. Now, Madam Clerk, let's go back on here. All right, so we're back on this record concerning Daniel Brown. This would be a good time to break. I need to collect my thoughts regarding the case that's coming in. I want to go back to the witness here, Mr., pronounce your last name.
Harrington.
Harrington. We're out of practice here. Doing trials, but I normally give this lecture before, and I'm gonna give it to you now. And this is it. No mm-hms or uh-uhs. You already know that. You cannot start speaking until they reach the period, because the lady in front of you can only record one person at a time. So be mindful when we come back on the record, let the prosecution finish their question, get to the period, pause a breath, and then start answering. If the opponent counsel stands up and says objection, don't talk. That requires a ruling from me. Counsel, I apologize. This is an add-on from last week, and I am suggesting that all of you take about 30 minutes for a lunchtime, and then let's see where I am when I get back to that case.
That would be fine, Your Honor.
Yeah, I want you back no later than 1:45.
Your Honor, can I leave my items right here?
Yes, because that entire matter is gonna happen on Zoom technology, so everybody can leave whatever they'd like. Once again, to you, sir, Don't discuss a case, don't give your thoughts or impressions, don't repeat any questions or answers, and you're free to leave the building and come back in. Be back at 1:45.
Understood, Your Honor.
All right, that completes this hearing. All right. Oh, Ms. Newman, are you there?
Yes, Judge, I'm here.
I'm just looking at the breakout room. So you have gotten out of the breakout room, but Mr. Williams and Mr. Calhoun and the accompaniment are still in there. So I'm gonna give them whatever time they need and then I'll call the case.
Well, Judge, if you want to put me back in there, I think they're just maybe don't realize they need to get out of the breakout room. I don't think they need any time. You want to put me back in there and I'll check
I
in?
don't, I think that the eligibility for you to go back in is already there.
Oh, it is? Okay.
Because you still have access to that room.
Hmm.
I don't know how to reopen it and put you back in there, but according to the screen, all three of you have access to that room. Two of them
Yeah,
are there.
that's beyond my technical capability, so I'm just going to turn off my video and try and reach Mr. Williams.
Do whatever you need to do. I'm just saying that I'm waiting until they come out and it's beyond my technical ability as well.
Judge, I gotcha. Hang on.
Just
If I could
telling you-
confuse things a little bit more, Your Honor, my name is Tracy Brame. I'm from the Innocence Project. If I could confuse things a little bit more, Mr. Williams says he's just waiting for someone to bring him out of the breakout room. So I think they're ready.
Well, believe it or not, I know how to do that.
Oh, okay. Well, I think you could, I think they're ready. You could bring them in.
I know. What is your name, ma'am?
My name is Tracy Brame. I am with David here. I'm just from the Innocence Project.
Okay, but I know how to force people out of the breakout room.
Okay. So yep, I just talked to Mr. Williams and they're just waiting to be forced out.
The only one in there is a jail. Now, there's a minute delay on the force out.
Okay.
Mr. Williams, I've got you. Are you telling me that the breakout room isn't needed anymore?
Correct.
Okay, I know how to force people out. Got it, but it's a minute delay and my clerk stepped out. She'll be right back and then we'll start.
Okay. Thank you.
She went to order a file, but I'm gonna tell her to come back because I'm not. Mm-mm.
Judge, I just want to say you can, we're on green.
Hold on.
Right, at your bench. Look at your-
Oh.
Even if you.
All right, Miss Newman, are you there?
Yes, Judge, I'm here. Hopefully my video will be better. I'm in the office today, so hopefully there's no lag.
Oh, you mean the sync? We've had.
The sync,
considerable
yes.
difficulties. So you're here, Mr. Calhoun's here. I think we have everybody that we had the last time. Are we good to go, counsel?
We are good to go, Your Honor. I don't know if WCC hearings, I think you have to unmute them when you're ready for them to speak.
Let's ask, Mr. Middlestat, talk to me. Can you hear, can you respond? No, hold on, let's get.
We can't hear you, Mike. We can't hear you.
Already sent the request.
All right, we sent a request for you to unmute yourself.
Yeah, but I don't think,
Hold on. There's a second delay. Try again, Mr. Middlestat. There you go. I think
Better?
that's it. Yep, you got
Better?
it.
Okay, great. Thank you, Judge.
All right, Williams, let's make sure, let's do a test with you. You're good, Mr. Williams?
Yes, Your Honor.
Judge, can Mr. Middlestat turn his volume up like Mr. Williams did?
I don't know. Mr. Middlestat, my stenographer is asking if you could raise your volume.
Is that better?
Probably not, but
Okay.
I think it's okay. It's loud enough for everyone. Okay. Good to go.
The court is calling case 06-013904 and case 06-013905 in the matters of the people of the state of Michigan versus Terrence Calhoun here today for motion hearing. Appearances for the record, please.
Prosecution.
good afternoon, Your Honor. Valerie Newman, Deputy Chief and Director of the Conviction Integrity Unit for the Wayne County Prosecutor's Office.
Thank you. Mr. Middlestat.
Good afternoon, Your Honor. Mike Middlestat of the State Appellate Defender's Office, appearing on behalf of Mr. Calhoun, who is seated to my right.
Okay, Mr. Calhoun, tell me your name, please.
Terrence Terrell Calhoun.
Thank you, Mr. Calhoun. To Mr. Calhoun's right, could I have your name, please?
Yes, Tabitha Harris, Special Assistant Defender from the State Appellate Defender's Office, with and on behalf of Mr. Calhoun, who's to my left.
All right, thank you. And sir, your name.
David Williams, Staff Attorney at the WMU Cooley Innocence Project.
Okay, thank you. Mr. Calhoun, I did this the last time. I'm going to ask you the same question this time after putting you under oath. Mr. Calhoun, would you kindly raise your right arm for an oath? Mr. Calhoun, do you solemnly swear to tell the whole truth, nothing but the truth, so help you God?
Yes.
All right, Mr. Calhoun, we are conducting this hearing. You can put your hand back down now. We're conducting this hearing on Zoom technology. Is that okay with you?
Yes.
All right, fair enough. All right, counsel, obviously, we were all here last week and the court directed the prosecution to review the evidence and or information that an officer wished to convey to this court. Based on the fact that neither the prosecution nor the defense have sought an adjournment of today's hearing, I am assuming that it is safe to conclude that the people intend to move forward with the motion and request today. Is that correct, Ms. Newman?
That is correct, Your Honor.
All right, Ms. Newman, did the officer provide the prosecution with any additional evidence and or information that was not previously known or considered in the investigation?
The officer did not, Your Honor.
Okay. And Ms. Newman, the court received today from via email an updated stipulated finding of fact and an agreed upon order to vacate the conviction and dismiss the cases with prejudice. Confirm?
Confirm, Your Honor.
Okay. Obviously, Ms. Newman, and to all parties, this case has received a lot of attention. and merits that we dot all of our dots and cross all of our Ts. And at this time, Ms. Newman, I would like to ask that the prosecution to articulate for the record the findings that support the people's decision to vacate Mr. Calhoun's convictions and sentence. And I'm assuming that you're going to read from the stipulated findings of fact and agreed order to vacate the convictions and dismiss the case with prejudice. Ms. Newman.
I can do that, Your Honor, no problem. So I'll do that first, and then I just had a few other additional things to add to it. So the document presented to the court is stipulated findings of fact and agreed order to vacate convictions and dismiss cases with prejudice. It reads as follows. The parties in this matter agree and stipulate to the following. 1, on September 26, 2006, victim 1, age 15, was grabbed and assaulted by a man near Fenkell Avenue and Blackstone Street in Detroit, Michigan. No physical evidence was reportedly recovered from the scene. 2, victim 1 described her assailant in part as having braids and a puzzle tattoo on his arm. 3, on October 27th, 2006, a man sexually assaulted victim 2, age 13, at gunpoint in an alley near Fenkell Avenue and Patton Street in Detroit, less than half a mile from where victim 1 had been assaulted. Victim 2 reported that the assailant had used a condom. Page 2. 4, a used condom was collected at the scene of the sexual assault of victim 2. And biological material was swabbed from inside and outside the condom. Samples were submitted to Relogenate Laboratory for testing, including DNA analysis. 5, police arrested Terrence Calhoun based on a composite sketch created from the description given by victim 2. 6, for the victim 2 assault, Mr. Calhoun was charged with first-degree criminal sexual conduct involving a weapon, kidnapping, assault with intent to commit sexual penetration, and felony firearm. See case number 06-013904-01-FC. 7, for the victim 1 assault, Mr. Calhoun was charged with kidnapping and assault with intent to commit sexual penetration. See case number 06-013905-01-FC. And I should have asked your court reporter, am I going too fast?
No, you're not, but since we have a break and while it's on my mind, I want to go back to line 4 and spell the name of the laboratory for her because I know that she looked up to me seeking that spelling. It is RELIA, same word, but a capital GEE. But I think you're going okay. I haven't, okay, she's got her hand up in a wait a minute sign.
I did want to ask, when she began reading, the very beginning, she said the date of 9 and then it blinked out something. Was it 9/6, 9/7?
Are you talking about paragraph 1 on September 26,
She said September 26?
2006?
Okay.
Any other questions?
No, thank you, Judge.
Okay, I can tell usually when she needs something and I caught this spelling. She has followed along without indication to me, but if you wouldn't mind a slower pace, Ms. Newman, I think it's simpler for her, easier to transcribe.
Absolutely, Your Honor.
Hold on just a second. Ms. Newman, I got another request from my stenographer.
She just needs to know that the sound is blinking on and off a little bit.
Okay, and you know what, Ms. Newman, you can see that my legal staff just came into the courtroom. We have handed to her what you are reading from, and I would note that you have read it so far verbatim. I think that will assist as well.
Okay. Very good. Then we're on to number 8.
All right,
In
so
connection.
she's moving that paper. Are you good?
Ready, Judge, thank you.
Go on.
All right, number 8. In connection with both cases, there were 2 orders for a forensic examination dated December 8th, 2006 and January 29th, 2007. A report by the Center for Forensic Psychiatry was issued February 21, 2007, which indicated that Mr. Calhoun has cognitive deficiencies, but was legally competent to waive his constitutional rights and stand trial. Number 9, on February 21st, 2007, Mr. Calhoun entered pleas of no contest to attempted kidnapping in case number 06-013905-01-FC involving victim 1, and to first degree CSE kidnapping and felony firearm in case number 06-013904-FC involving victim 2. Number 10, on March 28th, 2007, Mr. Calhoun was sentenced in case number 06-013905-FC to a prison term of 11 months to 5 years, and in case number 06-013904-FC to 15 to 30 years in prison for the first degree CSD conviction and the kidnapping conviction, consecutive to a 2-year sentence for the felony firearm count. Number 11, Mr. Calhoun was appointed counsel for the purpose of pursuing appeals or post-conviction remedies in both cases. Number 12, on June 15th, 2007, short tandem repeat and in parentheses STR analysis was completed on the condom collected at the scene of the sexual assault on victim 2. That analysis excluded Mr. Calhoun as a donor of biological material. Number 13, on September 10, 2007, Mr. Calhoun, after consulting with his appellate attorney, dismissed his appeal. There is no indication that the results of the STR analysis completed on June 15th, 2007 were provided to Mr. Calhoun's appellate counsel. Number 14, in January 2019, as part of the sexual assault kit and in parentheses SAK protocol, a SAK assistant prosecutor reviewed Mr. Calhoun's case. Based on the 2007 lab reports, SAK notified the State Appellate Defender Office, in parentheses SADO, of Calhoun's exclusionary test results on January 14, 2019. 15, on February 2nd, 2019, the Honorable Prentice Edwards Jr. appointed the State Appellate Defender Office to represent Mr. Calhoun as part of SADO's rape kit screening and DNA testing project. Page 3, number 16, SADO subsequently arranged for Bodie Technology to conduct additional STR analysis of the condom from the victim 2 sexual assault. 17, on August 14, 2019, and on September 2nd, 2019, Bodie Technology confirmed the earlier report completed in 2007 by Reliagene Laboratory and concluded that Mr. Calhoun was not the donor of biological material recovered from the condom collected at the scene of the victim 2 assault. Number 18, on January 10th, 2022, the Michigan State Police reported that a CODIS report had matched the DNA recovered in the victim 2 assault to another individual who is currently charged with other sexual assault offenses in the Detroit area that are alleged to have occurred between 2007 and 2014. Victim 1 described her assailant as having braids and a puzzle tattoo on his arm. Mr. Calhoun had neither braided hair nor a puzzle tattoo. During the post-conviction investigation, the Wayne County Prosecutor's Office Conviction Integrity Unit conducted a national search of law enforcement databases. The search turned up only one individual with a puzzle tattoo on his arm. That individual is currently incarcerated in the Michigan Department of Corrections for sexual assault convictions. 22, since June 15, 2007, Mr. Calhoun has been excluded as the donor of the DNA recovered from the condom found at the scene of victim two's assault. There is no indication that the evidence was provided to the defense prior to 2019. Subsequent testing not only confirmed Mr. Calhoun's exclusion, but also revealed a match with another individual who is currently charged in multiple sexual assaults in Wayne County. 23. Additionally, victim one described an assailant who definitively cannot be Mr. Calhoun. 24, considering these facts, the parties hereby stipulate that Terrence Calhoun's convictions and sentences in cases number 06-013-904 FC and number 06-013-905-01 FC be vacated and both cases dismissed with prejudice. It's dated today's date, April 27, 2022, and signed by myself, Michael Middlestat, and David Williams. There's an additional document that's just the order. Did you want me to read that into the record as well, Your Honor?
No, but I do want to say something. At the conclusion of reading paragraph identified as 24, you left out CMCL 770.
Oh. I did. Thank you for catching that, Your Honor.
Okay, and I would note that the document was read verbatim by Ms. Newman. This is the document that the court has in its hand and received today. And there's electronic signatures of Valerie Newman, Michael Middlestat, and David R. Williams. I do have the order, and I'm happy to read that into evidence at the end of the hearing if that's acceptable to everybody. Okay with you, Ms. Newman?
Okay with me, Your Honor.
Mr. Middlestat?
That's fine, Your Honor. Thank you.
I would also, well, let me get to that in a moment. I would go back to you, Ms. Newman, because you said prior to the court asking if the prosecution could articulate for the record the findings that support the people's decision to vacate Mr. Calhoun's conviction and sentence, you had commented that you wanted to say something, and I'm offering you that opportunity at this time.
I appreciate that, Your Honor. So I want to be clear because of what happened last time. I appreciate you, Judge, starting the hearing by asking about the information that had been provided. But I want to make sure that from the prosecutor's office that I am being fully transparent with the court and with the public, because I think what happened raised the specter that somebody might, could infer that maybe we were trying to hide something. So I don't know if this can be captured, but I just want to show it for the camera. This is exactly what was given to me that had been, that the officer tried to give to you, Judge. So it's a manila envelope. On the front of the manila envelope, it says defendant Calhoun Terrence, give some information. It has a command file number, a warrant number, officer in charge of the case, Jose Ortiz, and gives the complainant's name that I'm not, an address, which I'm not going to put on the record, a charge and some other information on the front of this file. Contained in this manila envelope is the original police file from victim two's case. And so I just want to tell the court that not only have I reviewed it, but my detective reviewed it. Another member of my staff reviewed it. We all compared it to the police file that we already had in this unit, and it is identical. I will also note for the record that what is not contained in this file is the June 15th, 2007 report from Relagene indicating that Mr. Calhoun was excluded as the donor to the material on the condom that had been tested. So I just want to make sure and that I had informed the defense as soon as I reviewed the file. I got in contact with all the defense attorneys and let them know that this file was a file that has already been turned over to them and that everyone already had in their possession. So that's, I just want to be crystal clear on that point. I also want to, I want to thank the court for being forthright last week. It's always good to, double check what's going on. It never hurts the process to shine more of a light on things. And so, we had the opportunity to do that, but I also don't want to lose sight of the fact that really today is about the myriad of things that went wrong that caused the wrongful conviction of an innocent person. There's so many things that happen in this case that are troubling. And while this is ostensibly a DNA exclusion case, there is a lot more going on here that supports Mr. Calhoun's innocence than just the exclusion from the condom. We have the fact that one of the victims gave a description of her attacker that could not be Mr. Calhoun. And so there were so many things that were missed along the way in terms of this investigation, that while we're not relying on those things to say to the court, this is why you should vacate the convictions, I think it's important for the court to know that there are a myriad of things in addition to what's in the stipulation that support the fact that Mr. Calhoun is innocent of both of these the attempted sexual assault and the completed sexual assault. Furthermore, when we did the victim notification, one victim we were unable to locate, so we were not able to speak with her. But the victim of the completed sexual assault, we were able to locate. We spoke with her and her guardian, and the response when we laid out all the information like we've laid out today in the court and other information that we have that goes to his innocence, the response from her guardian is, I hope you're going to get that man out of prison as quickly as possible. So, the victim, at least the victim that we spoke to, is completely on board with everything that's going on here today. We offered them the opportunity to come to court to speak, and they declined to do so. But I think that's an important piece of this, especially from anyone in the public who's watching this, to know that as part of the CIU process, we have a very, very intense and thorough process that we undergo when we pick up a case. And we interview people, we look at the police files, we look at all the original evidence, we look at the new evidence, we evaluate the new evidence, and then we come to a determination after we've done, a really intensive investigation. These are not decisions that we make lightly. I don't make any recommendations to Prosecutor Worthy lightly. I understand as the head of the Conviction Integrity Unit that I know not only have an obligation to this office and this community, but to every Conviction Integrity Unit across the country. Because if we make a mistake, it undermines this mission for everybody, not just for the people in Wayne County. So we undertake this with great gravity and full understanding of what it means to come to this court and say, Judge, a mistake has been made. This is everything that supports it. And this is why we're asking you, to take these actions. I also want to highlight just a couple of things, which is one, I want to thank Chief White of the Detroit Police Department, who came out with a very strong statement condoning what this officer did in this case, as well as Chief Judge Kenny, and as well as the court for bringing it to light, because this is the only way the system can work. If we're transparent and we disclose and we deal with things out in the open. So I do want to say, that I appreciate how everyone has quickly, condemned this officer's actions of trying to do something and hide this in the dark and do something surreptitious. And I also just want to emphasize how troubling this case is, that the CODIS hit on the condom came back to someone who is now charged with multiple sexual assaults. It highlights the fact that when the police get it wrong and we lock up the wrong person, it leaves the true perpetrator on the street free and clear to continue to commit more crimes. So doing the work that the Conviction Integrity Unit does is vital to the community. It's not only vital to the individual like Mr. Calhoun, who's been wrongfully convicted and sat in prison for the last 15 years for a crime he didn't commit, but it's vital to the community. Because if these cases, if the wrong person just keeps getting blamed for something, then the real person gets to stay out there, and it creates, it's a safety issue for our community. So I really, I'm very thankful to Prosecutor Worthy that she has the courage to have formed this unit and to support this unit, and for us to be able to do this really very, very critical and important work that helps keep the community safe. It protects the integrity of the justice system by having a safety valve that people can come to us if they're claiming a wrongful conviction. And that we have a court that was in yourself, Judge Ramsey, that was judicious and careful and forthcoming about everything that's happened in this case. And with that, I just ask that you sign the order and grant the relief requested.
Ms. Newman, for clarity, I just want to ask you one question because I wasn't certain. You identify in the stipulated findings of fact, victim 1 and victim 2.
Correct.
In your statement to the court, you indicated that you were unable to find one of the victims, and then you did have conversation with the other. What victim did you have conversation with, victim 1 or 2?
2, victim 2.
I didn't follow that, and I just wanted that to be clarified.
Sure, thank you, Judge.
All right, and just in response to your statement about the circumstances of last week, it was certainly the court's intent to ensure that there was an opportunity for due diligence. And the court must ensure that justice is done, and simply gave an opportunity for a second look. And thank you to everybody for your patience, understanding, and the additional efforts that went forward since we were all here last week. Mr. Middlestad, I'd like to ask you, one, if there is any further comments that you would like to place on the record today, and second, whether or not Mr. Calhoun wishes to address the court, and how you'd like to proceed, I'll leave in your hands, sir.
Yeah, just briefly on behalf of myself and Mr. Calhoun, I would like to thank the Wayne County Prosecutor's Office Conviction Integrity Unit and Prosecutor Worthy for putting so much work with us in on this case. This has been a painfully slow process for us and for Mr. Calhoun, but we understand, as Ms. Newman just explained, that there needs to be confidence in a decision like this, and that much due diligence is needed so that no stone is unturned to make sure that we have the facts right. And we appreciate that they took the time not only to hear us out and to do the independent investigation that was necessary, but also to look into the new information. I share a lot of what Ms. Newman has said about the various flags that are present in this case. Many of these flags we see often with wrongful convictions and in exoneration cases. I would also say too, that it is very concerning that DNA evidence that excluded Mr. Calhoun did not make it into the defense's hands. That is a very concerning development. And there have been ethical rules and whatnot that have been changed in light of things like this happening, to prevent things like this happening since 2007. In my opinion, there is a cloud over this investigation. And what Mr. Kane did last week was more befitting of a vigilante than that of a public servant. And what he did only darkened that cloud. It did nothing to remove that cloud. And I appreciate the fact that the information was turned over to us and to the prosecutor. And it is clear to me that no new information was brought to the table, and that Officer Kane was just making one final plea to preserve this conviction. But again, I thank the court, and I thank Ms. Newman and the Detroit Police Department, and would ask that Your Honor accept the stipulation in order and release Mr. Calhoun immediately.
Mr. Middlestad, thank you for your comments. Does Mr. Calhoun wish to say anything?
Could I put you on mute just for a second, your judge, and talk to Mr. Calhoun to see if he would like to say something?
Absolutely. Take the time that you need. We're gonna go pause off the record.
Terrence, would you like to speak, or you don't have to
No,
if you
we
don't?
can still hear you. Hold on a second. We can still hear you and we're live on YouTube, so you
I
need to
muted.
mute yourself.
I muted them.
We did it on our end. I think you can still hear us. We did it on our end, and I'm gonna formally go off the record.
He needs to unmute.
Is he back?
Judge,
Okay.
we are back, Judge. I don't know if you need to go back on the record.
Oops, what did you just say? I am back on the record.
Okay, thank you, Judge. We're back. I understand we're back on the record. I have spoken to Mr. Calhoun, and he has determined that he does not wish to speak at this time. My co-counsel in this matter, Tabitha Harris, would like to bring a motion, but I'm not sure if it should be done now or after the court makes a ruling on our proposed stipulation.
Well, I'm gonna get there in just a second. I do recognize that it's Tabitha Harris, correct?
That's correct, Your Honor.
All right, and Mr. Williams, you are from the Cooley Innocence Project. Anything from you, Mr. Williams?
No, Your Honor.
All right, and Ms. Harris, let me hear your motion at this time, please.
Yes, Your Honor, thank you. We would like to ask that the court sign an order regarding the destruction of biometric data and arrest records with the Michigan State Police, Your Honor, and we would make that motion if Your Honor does grant the motion for Mr. Calhoun, the vacation of Mr. Calhoun's charges. Your Honor, as you're aware, Mr. Calhoun is going to be residing with his family out of state. They're going to be taking him, if Your Honor grants the motion, they will be taking him out of state to reside with them. And this would be expedient, Your Honor, and they would be able to handle this while they're here in the state of Michigan. Thank you.
Okay. All right, I'm gonna get to the destruction of the biometric data and the arrest records following a ruling on the motion. Anything else from any party?
No, Your Honor, not from the people.
All right, the court has both read prior to this hearing as well as certainly placed on the record the stipulated findings of fact and agreed upon order to vacate the conviction and dismiss these cases with prejudice. And the court is also in receipt of an order that was presented to the court indicating that a session of the court held today on April 27th, 2022 before myself, that the matter has come to the court based upon the party stipulation by the findings of fact that were read into the record, and the court otherwise being fully advised regarding this matter. The court is going to grant the motion and hereby order that the convictions and the sentences in the above caption matters be vacated. I would indicate that that is Circuit Court number 060139 04-01FC and Circuit Court number 06-13905-01FC. It is further ordered that all of the charges in the above captioned matter are dismissed with prejudice, and the court is signing the document that has been presented to the court. Regarding Ms. Harris, your motion, I was also presented two orders, and this is on two different pages, identifying separately case number 06-13904-01 and 06-13905-01. These are orders that reference different charges. So I think I'm going to go back and do this separately, starting with 13904-01. It indicates count 1, criminal sexual conduct in the first degree, count 2, kidnapping, count 3, felony firearm. The MCL PAC code is identified indicating that Terrence Turnell Calhoun has filed a motion requesting that his biometric data and arrest record be destroyed by the arresting agency of Michigan State Police as required by law. At the hearing in front of myself, it's marked that the court is going to order an immediate destruction of the biometric data and arrest record of the defendant, Terrence Turnell Calhoun, and provide certification to that fact. And the court is going to sign and date this matter with by bar number P39321. The second page reference the second file 0613900501. These are forms MC 392. The forms are identical in nature. And on the case ending in 905, there is count 1 kidnapping attempt. It reads identically. And yes, the court is going to grant the request and destroy the biometric data and the record in the arrest record of the defendant, Mr. Calhoun. And I think I heard you say, Ms. Newman, that you are in the office and you can certainly get copies of the court's orders momentarily.
All right, I'll come down to the courtroom, Judge. Thank you very much. And then you'll send that right to the MDOC so they can start processing the, or Brant will.
Today, and they are well aware of the urgency of the matter, and we'll ask them to take the time and do so immediately. It will be out of our hands by the close of business today.
Thank you, Judge. We appreciate it.
Anyway. All right, Mr. Calhoun, good luck to you. On behalf of the Wayne County Circuit Court and myself, I apologize for the delay, and I hope that you understand that the court's intent was to ensure that justice is done, and my very best to you, sir.
Thank you.
Else, you're welcome, Mr. Calhoun. Seek the best in yourself every day, Mr. Calhoun.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Off the record.
All right.
Okay. Hey. You did it.
The hearing's over.
We did it. We did it.
Right, you gotta go get your Arby's. All right.
Okay, we're back on the record, but I should have asked you to, we're gonna pick up where we left off, correct, gentlemen? Why don't you give Mr. Herndon, officer, would you mind opening up the witness room, please? Thank you. Where did your shield go? Okay. We have another one if you need a new one. I'm sorry, my mistake. I thought I was off the record. Madam Davis, we're gonna go back on the record. All right, tell me your name, sir.
Karandi Harrington.
All right, I thank you for your patience, and we're gonna pick up where we left off. Mr. Prosecutor, you were still in a direct.
Yes, sir, thank you. And Mr. Herndon, at the time, before we left off for the break, we were discussing the date of June 11th, 2020. You testified, you were at your home, sitting on a porch, it was a nice sunny day,
Yes,
warm outside.
yes,
You saw the defendant, you called the police, correct?
correct.
And what happened? Did you arrive at the location?
Yes.
And what happened next?
They came and asked me what was going on. I told them. They approached Mr. Daniel Brown.
What did you explain was going on?
I explained that a complaint had been made and I had been instructed by the police that if Mr. Daniel Brown appeared near me to notify them.
Okay, and that's what you did?
Yes.
Okay, and then what happened next?
They went in, they arrested Mr. Brown.
And you observed them put handcuffs on Mr. Brown?
Yes.
Did you observe anything else after that?
I observed them tow his vehicle away.
Did you ever observe Mr. Brown near the vehicle?
Yes, he pulled up in the vehicle.
And this was that silver or gray Hyundai?
Yes,
Okay. He pulled up in the vehicle. Where did he park that vehicle?
in the driveway of the neighbor's house.
And what was that neighbor's name again?
Deborah,
Okay. And she had a nickname?
Nene.
Okay. You saw them put handcuffs on the defendant and you saw them tow his vehicle.
Yes.
Was that a tow truck, police tow truck or? regular tow truck?
A tow truck that the police called.
Okay. And did you observe the officers going through the car or anything like that?
I did not.
And what did you do after they put handcuffs on Mr. Brown?
Just sat on the porch and just watch what was going on.
Okay, and after they put the handcuffs on Mr. Brown, what did they do next?
They put him in the car. They left with him. His mother came. He was shouting, saying that the police were trying to rob him, something like that. It was some type of misunderstanding going on. He was resisting a little bit. The police got him in the car and they took him away.
Okay, is that the last time you saw Mr. Brown?
No.
That's the next time you saw Mr. Brown after that?
Mr. Brown came to Deborah's house several times since this ordeal has happened. I was understood that it was a condition of his bond. He was not to be on the block. He's come there several times.
Did he ever make any threats against you?
No, he would come. I would observe him come. He would go in the driveway of that house, and I would see him. Sometimes I would come outside and see him leaving from there. I would come outside and see him parked there. But that's it. I just would see him.
Okay, and so there's no more talk about the AR pistol?
No.
Okay.
And then I seen him again when I moved out of the residence. Him and his mother came to the residence and I seen him then. And nothing transpired during that ordeal as well.
Okay, Mr. Hearn, I appreciate your time and your patience this afternoon. If you guys have no further questions.
All right, thank you. Now, Mr. Harris, Mr. Brown's attorney is going to ask you some questions. Mr. Harris, sir?
Mr. Harrington, I'm gonna ask you a series of questions, and if you cannot hear me, please tell me to speak up. And if you don't understand my question, please, tell me you don't understand.
Okay.
Okay? Mr. Herndon, have you been convicted of crimes involving theft, dishonesty, or false statement within the last 10 years?
Do I have to answer that question?
Unfortunately, you do, sir.
Yes.
And what were you convicted of, sir?
I don't recall all of the convictions.
If I were to tell you that on January 22nd, 2015, you were convicted of receiving, concealing stolen property, would that be truthful, sir?
Yes.
Mr. Herndon, you made a statement to the police on May 5th, 2020, is that correct?
I don't recall.
He had said earlier he didn't recall the date.
May 5th, 2020, if I might remind you, is the date that you have been testifying about with regards to Mr. Brown being at the residence next door and in the backyard.
Okay.
So let's stay on that particular date.
Okay.
Did you make any statements to the police on May 5th, 2020?
Yes.
Okay. And those statements were truthful?
Yes.
Okay. And did you make any statements to the police on May 7th, 2020?
I do not recall.
Okay. Do you recall speaking to a police officer? A detective Nicole Moore on
Yes.
the telephone on 12:25 PM on May 7th, 2020?
Don't recall the date. I do remember having a conversation with Detective Moore. Yes.
Okay. I'm gonna hand you a document to refresh your recollection. May I approach you?
You may.
This is refreshes recollection. Would you please look at that and see if that refreshes your recollection as to the date that you talked with Detective Nicole Moore? You look in the upper left-hand corner. I think that might help.
All right, Mr. Herndon, when you're refreshing your memory, just look at the document, read as much or as little of it as you need to. And then I'll ask Mr. Harris to redirect the question to you.
Does that refresh your recollection as to having a telephone interview with Detective Nicole Moore on May 7th, 2020?
Yes.
And when you spoke with Detective Moore, you told her the truth. Is that correct?
Or what was, some of those things are not specific to what I saw. So one thing specific
Okay, but hold on,
Please
just
listen
just
to my
answer the
question.
question. Did you tell her the truth?
Yes,
Next question.
And sir, on May 5th, 2020, you were not the owner at 16165 Steel, is that correct?
correct.
And at that time, you knew Josette Crumble was the owner of 16165 Steel on May 5th, 2020, correct?
Correct.
And on May 5th, 2020, you were not leasing 16165 Steel from Josette Crumble, is that correct?
Listening from Andre Williamson.
So please listen to my question. You were not leasing the property from Josette Crumble, is that correct?
That is correct.
And you know who Josette Crumble is that correct?
It's Andre Williams' sister.
Okay, and you also know, or do you know that Josette Crumble is Daniel Brown's mother?
Yes,
Okay. And on May 5th, 2020, you were not renting 16165 Steel from Josette Crumble, correct?
again, I was renting it from Andre Williams.
Please listen to my question. You were not renting 16165 Steel from Josette Crumble, is that correct?
That is correct.
I'm gonna hand you a document that is marked as Exhibit A. May I approach you?
You may. I just want to clarify it's proposed exhibit A.
Yeah, proposed exhibit.
Go on.
Would you look at that document, sir?
Yes,
And at the top of that document, what's the very first two words, if you could tell this? The top of the second page, top of the second page,
the very first two words,
first two words.
Bernard Youngblood.
Okay, let me see that. You're wrong. Okay. Read that word there.
Which one?
These two words right here,
Warranty deed.
warranty deed. And read that wording and the language there, right? Two,
Two,
yes.
to second party, guarantee, Jonette R. Crumble, a single woman, whose post office address is 16205 Steel Street, Detroit, Michigan, 48235.
Okay. On this first page, sir. Oh, on the second page, it gives you a date. Read the language and the date.
Known by all men by these presents, execute this 6th day of January 2009, by first party guarantor, U.S. Bank National Association, and trustee of the Structured Asset Investment Loan Trust 20059.
Right? You know, so sir, have you seen this warranty deed before?
Yes,
Okay, and so, when did you first see this warranty deed?
I first saw the warranty deed after I had paid Andre Williamson and signed the contract to take possession of the house. We had made a land contract agreement that I would purchase the house for $40,000. I would give him 10% down and pay him $1,000 a month for 36 months.
Your Honor,
After we completed that, we went downtown, and I got a copy of the
Just
deed,
hold on.
and it said Josette Crumble. And that's when I first seen it.
Okay.
When did you see this document?
I don't remember the date. I came downtown here. I went to the building. I paid $10 and they gave me a copy of that. And I told Mr. Williamson that I could not purchase the house from him because he is not the deeded owner, but I would rent it from him.
What year did you purchase? I mean, what year did you get that warranty deed?
I never, let me see. But this is 2022. I believe it was in 2019, somewhere in 2020.
Okay, so,
But I'm still confused. I don't know the answer.
yeah, I got that. And I'm gonna try to clarify.
Okay.
You said 2019?
I don't, let me see, I think my lease started February 1st. May have been 2019. I kind of lost track, but
Okay, so.
prior to that,
Well, no.
No, but hold on.
Okay.
So, but I'm still confused. The first time he saw that was when he came downtown, went up to a floor, paid $10, and it was given to him. That was your answer when you first saw that?
correct, that's the first time I saw that, when I came and bought a copy of it myself, yes.
And when you say come down here, I think you mean the city county building?
Yes.
Culminating
No,
on
yes.
municipal.
No, he doesn't mean the city county building, just can't do it.
Oh.
I went, let me see, I think I went to 400 Monroe.
Correct.
Okay, my mistake.
Yes,
Okay, so that's the date that you're seeking, the date he went and paid his $10 and got it.
Correct.
I do not
Okay.
recall that date. It was,
You did, all right.
Can
Wait,
you
wait, wait, wait,
recall
wait.
the year?
I believe 2019, me and Andre Williamson, we signed the agreement, we came down here, we went to the water company, I paid the water bill, put the water in my name. We went and got the deed, then I got the deed, I said, this house belongs to Josette. He said, I paid my sister $23,000, I'll have her sign over the deed and I'll sell you the house.
Okay. But on that date in 2019, you knew that this house was deeded to Josette Crumble, correct?
I did,
You knew that it was not deeded to Andre Williamson, correct?
when I received it, that's when I knew, yes.
Okay, and so did you sign a lease with Andre Williamson before you got the deed that you paid $10 for?
Yes,
Okay, hold on, let me think that through.
Okay,
He signed the lease
yes,
before he went and got that document.
correct.
Can I,
Is that correct, Mr.?
yes, it is.
Okay,
can I ask one question? Because there's a lot of movement here. When you came and when you paid your $10,
Yes.
were you with anybody or were you by yourself?
I was with Andre Williamson.
Okay, all right, I'm just trying to follow this.
okay. And I move for the admission of defendant's proposed exhibit A.
Any objection?
Judge, I'm actually objecting to this whole line of questioning. I don't see how this is relevant to whether or not Mr. Daniel Brown pointed a gun at the witness or not. I'm not understanding. This is great for landlord-tenant court. This is wonderful, but this is a felonious assault case.
Excuse me, Your Honor, the prosecutor went over the lease regarding Andre Williamson. I'm trying to establish that this witness was illegally squatting in the house at the time that May 5th, 2020, when this happened. He shouldn't have first never been there. And he is also testifying, or may testify to, he did testify to evicting Mr. Brown in February of 2020. He's got no power to do that.
And how can he be squatting in a place that he was leasing?
Well,
He thought that Mr. Williamson had the authority to lease it to him then. He didn't purchase the home.
All right,
It was deeded
I
someone
get
else.
both of your arguments, and I certainly heard your opening statement, Mr. Harris, that is
Your Honor,
Provided a black
can I make one comment? This witness has now testified that in 2019, he went and got the warranty deed and recognized that the lease that he had signed previously was not valid.
That is not the testimony, Judge.
all right. That's an argument, Mr. Harris.
No,
All
no.
right, just pause for a minute.
My argument is only because the prosecutor is saying it's not relevant, and I'm saying it is, given what this witness has just testified to.
And I'm maintaining my.
He
objection to
opened the
relevance.
door, Your Honor. He opened the door about this whole leasing business.
You opened the door, your opening statement.
Well, my opening statement doesn't count.
All right, there's not a jury here. There's not a jury here. And I would certainly agree that the felony information before this court speaks only of the date of May 5, 2020. Those are the relevant facts before this court. I'm gonna receive this. I've heard about it in the opening. You've got testimony about who he allegedly rented from, and now there's this entanglement with whether or not Mr. Williams may or may not have done stuff correctly. But I'll receive it. I can compartmentalize all the reasons why. Go on. So let's not entangle this case with what other people are doing. This case is about Mr. Brown, not his mother, not his brother, not his uncle, mother's brother, and landlord issues. I concur.
Thank you, Judge. Ruling?
I did say I'd receive it. There's no jury here.
Thank you, Judge.
But I wouldn't mind taking a look at it, having it published to me.
Everyone.
Exhibit A,
okay.
received,
Exhibit A.
published. I'd like to see it. You can just hand it to Miss Shepherd. She'll pass it to me. I'll take it to our little mail slot. Thank you. Now, Mr. Harris, this document is the defense's document, not this gentleman's, correct?
Correct.
All right, just making sure. Go on.
Now, on May 20th, May 5th, 2020, sir, did you tell the police that you had to evict Mr. Brown from this property?
Yeah.
And you know what the word evict means, don't you, sir?
Yes,
You know it's a legal process, correct?
yes,
You have to go down to, if the property is in the city of Detroit, you have to go down to the city of Detroit and put in some paperwork that tells a judge that you want to have this person removed from that property. Is that correct?
yes.
You didn't do that, did you?
No,
I didn't get your answer to
His
that.
answer was no.
No, okay. So when you told the police on May 5th, 2020, that you had to evict Mr. Brown, or that you evicted Mr. Brown, that wasn't the truth, was it?
yes,
But wait a minute. It wasn't the truth. Was it? I don't know what the yes goes to. Did you?
the truth, yes, I evicted him, but the word evict, by you putting it in the dictionary definition, I guess the proper word would be, I relocated. Because evict is a legal terminology, and I didn't do the legal terminology of evict. So to proper determine what I did with Mr. Daniels is I relocated.
So when you told the police that you evicted Mr. Brown, that was not the truth, correct? On May 5th, 2020.
Judge, I object to this argumentative.
It's not argumentative, it's
I understand the question, and I have heard his answer, Mr. Harris, and he's already answered your question. He
On May
answered that
7th.
question. It's been asked and answered, and that I'm gonna ask you to move on.
Thank you,
Okay.
Judge.
And on May 7th, 2020, when you talked to Detective Moore, you told her that you had to evict Mr. Brown. Is that correct?
Same thing, relocate him from the premises, because I was in possession of the premises, and he was aware of it, and he knew that he had to leave from there without going to court. His uncle told him that, hey, I've leased the house to this gentleman.
Sir, please answer my question.
The only question in front of you is this: you told the second officer on May 7th that you had to evict, using the word evict.
Yes.
You use that.
I used the word evict, yes.
Next
Okay.
question.
Okay. And that wasn't the truth on May 7th when you told the officer you had to evict Mr. Brown. Is that correct?
Again, I relocated Mr. Brown. If the word evict was, I didn't use it in its verbatim definition context, then
Okay.
Next question.
Now, you, so essentially, since you told this court that you knew the deed was not in Mr. Andrew Williamson's name, but in Josette Crumble's name, and that you did not have a lease from Josette Crumble at the time, you were squatting at that location, is that correct?
that is not correct.
You were squatting there because you put your family in there, is that correct?
That is not correct.
You did not get permission from Josette Crumble to change the locks in that location, is that correct?
Correct. I had no,
And you did not give Josette Crumble keys to the new locks that you put in that location, is that correct?
correct.
Now, do you recall testifying on August the 11th, 2020 in the 36th District Court about this matter?
Vaguely.
Okay. Was your testimony on August 11th, 2020 accurate?
It was 2 years ago to the best of, as
Pardon?
far as I know, yes.
Yes? And was your testimony truthful on August 11th, 2020 regarding the events of May 5th, 2020?
Yes.
You, on August 11th, 2020, did not tell the court that you had permission to live at 16165 Steel by Josette Crumble, did you?
No, because that's not how I got into the property.
Okay, you didn't tell the court that, right? On August 11th, you didn't tell them you had permission from Josette Steel Josette Crumble to live at the 16165 address,
I
correct?
did not tell the court that I had permission to live there by Josette Crumble. No, I did not.
And you did not tell the court on August 11th, 2020, that you were squatting at that 16165 location, correct?
I did not tell them that I was squatting.
And you were not truthful when you told the court, when you testified that you legally lived at 16165
Yes, I did.
Steel, correct?
That is the truth. The truth is that I did legally, that I live at 16165 Steel, and that is what I told the police. My mail and my driver's license and my physical person being there proved that. And all the utilities and water bills included.
So it's your position that you lived there, but you didn't tell the court that you lived there illegally, is that correct?
I was not living there illegally.
Well, you didn't have permission from Josette Crumble to live there, correct?
Your Honor, objection, ask and answer.
We've gone through this. I've heard that answer.
Okay. Now, you told the court on August the 11th, 2020, that you walked out your front door and walked across the street to get something out of your van.
Yes,
You recall that?
I do.
You didn't tell the court today that you came out of your house and walked across the street to get something out of your van, did you?
No,
Mr. Harris, I need to stop you. You said August 11th, 2020.
Yes,
August 11th? Okay.
the preliminary examination, Judge, August
Oh,
11th.
August 11 is, I'm sorry. My apologies. I'm thinking of that
May
June
15th.
date.
June. Oh,
Okay, I didn't follow it for a second. The preliminary exam was held on August 11th of 2020. I stand corrected. I just couldn't get the date in my mind.
That's where I'm at now.
I got it now.
Okay. So you didn't tell this court that you walked out of your house on May 5th to go get something out of your van. Is that correct?
I did tell them that.
You told this court today?
No, you didn't specify today. You asked if I told the court.
No.
So I did at some point in time tell the court, tell someone, I remember walking across the street to my van. I do remember that.
Okay. Let's make sure we got this clear.
Okay.
You told the court on August 11th, 2020, you walked out the front door and walked across the street to get something out of your van. You remember testifying to that?
Yes,
Okay. You did not tell this court today that that's what you did,
correct.
correct? Okay. And when you talked to the police on May 5th, 2020, you did not tell the police officers that arrived at your house that you walked out of your house and went to your van to get something out of your van. Walked across the street to get something out of your
I
van.
do not recall.
Okay. And when you talk to Officer Nicole Moore, excuse me, you didn't tell her that you walked out of your house to go across the street to your van to get something out of your van. Is that correct?
I do not recall.
Okay. Well, let me hand you this document and let us see if it refreshes your recollection.
Could you identify what you're handing him,
I'm
please?
handing him the statement that he made to Nicole Nichols by telephone interview.
Nicole, who?
Nicole Moore, I'm sorry, not Nicole Moore, Detective Nicole Moore.
That's the same document he looked at.
I've seen this
previously,
already.
correct?
Yes, you've seen that already, correct?
Yes,
Does that refresh your recollection as to whether you told Nicole Moore that you walked out of your house and went to your van to get something out of your van?
no.
You know what? Why don't we just leave this right here?
All right, I would note for the record that that document is on the ledge to the left of the witness on the witness stand.
And sir, if you need to refer to that document, please feel free to grab it when I ask your question.
Yes, sir.
Okay? Now, you also told the court on August the 11th, 2020, that while you were walking back to your home, Daniel Brown is shouting at you. You recall telling the court that on August
Yes,
11th, 2020?
yes.
Now, I'm gonna hand you a series of photos. Proposed exhibits B through, I think, E. E. You can have it right there.
No.
I'm going to ask you, what am I handing you?
This is a picture of my previous residence.
Okay, that is proposed exhibit. Is that
What's the
what
bottom
is-
right say?
B,
B?
Defendant's
and-
Exhibit B.
And when you say proposed residence, do you mean the address in question on Steele?
This is the address in which I was living at the time that the defense occurred.
Okay, go on.
Okay. Does, in that photo, does it identify an address?
16165.
And the street is Steele, is that correct?
Yes.
Would you look at defense proposed exhibit, C?
C?
C,
Yes.
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 And what does that What does that,
It shows a picture of 16165 Steel and my neighbor's home adjacent.
and you would agree with me that that's the home of Deborah Walker, commonly known as Dee Dee?
Yes,
Okay, you called her Nene. Were you confused about that?
I call her name.
You call her Nene.
Yes.
Okay, have you heard her been called Dee Dee before?
Yes,
Okay. So you, defense proposed exhibit C, you recognize that, right?
the two houses?
Yes.
Yes.
Okay. Would you look at proposed exhibit D? What is that exhibit?
It's a picture of Deborah's house.
Okay. And would you look at proposed exhibit E?
Another picture of Deborah's house.
Move for admission of defense proposed exhibit B through D.
No, B through E.
B through E, I'm sorry.
Any objection, Mr. Andrea?
What's the purpose?
Well, we've been discussing those two houses, but I shouldn't be answering that question.
It will give the court a clear definition as to what the area looks like, what the two houses look like, and what the testimony will be regarding these two houses.
And perhaps distance.
And it's relevant.
I'm going to receive them, but I'd like you to publish them to me while it's contemporaneous, so I can just look at them, please, Mr. Harris. I'll just walk and have you hand them to me. Thank
There
you,
you go.
sir.
Guarantee you.
You're not waiting for me, are you? Mr.
Yes, I
Harris?
was, Judge. I was. waiting.
Oh, okay. Fair
Yeah,
enough.
that's
My apologies.
Okay.
I'm sorry. You may continue.
Okay. Now, you remember testifying this morning that, Nene, as you described her, was out there in the driveway, in her driveway of her address when Mr. Brown's car and Mr. Brown were there present, correct?
Incorrect.
Did you tell this court that Nene waved you over?
I did,
Okay, where was Nene when she waved you over?
on her front porch.
Okay, was there ever a time where Nene came off of her porch?
No,
Was there ever a time when you,
well, let me correct myself
Wait,
with the
wait,
answer.
hold on. You can't,
Okay.
this question and answer,
Okay.
sir.
was there, you recall testifying that that Mr. Brown was alone when he threatened you, is that correct?
Yes,
He did threaten you allegedly in Nene and when he was parked in that driveway, correct?
correct.
And Nene was present, correct?
She heard what he was saying.
I'm
Yes.
not asking you whether she heard what he was saying. I'm asking you that Nene was present when you allegedly were threatened by Mr. Brown, correct?
Yes.
Okay.
At some point, she
You
went
didn't tell
into
the
the house.
truth when you told the court that Mr. Brown was alone when he threatened you. Is that correct?
When I said alone, he was alone in the vehicle.
Okay, I'm going to refresh your recollection.
Oh,
You recall being asked this question and given this answer. Question,
Page,
page 8, lines 2 and 3. Question, now, is he alone? Answer, yes. You didn't say, do you remember being asked that question and given that answer?
I do not. 'Cause I'm confused about something I would like to clarify with you so we can get on the same page.
No, no. I'm
there's
gonna
two-
ask you some questions.
Okay,
doesn't
cool.
work like that, sir.
I agree.
So he said he doesn't remember that question
So
and answer.
you don't remember that question nor that answer.
I'm confused about what threat he's talking about. He's talking about verbal threat
Okay,
or
all right,
gun
so,
threat.
so this is the response. I don't understand the
I do
question.
not understand the
So,
threat in which you're speaking of.
Okay.
Mr. Harris, we've talked about more than one date here,
Okay, I'm talking about Mayfield.
okay?
And what
I'm
threat,
talking about
and
Mayfield.
what threat?
Okay, so do you recall being asked this question and given this set of answers? Page 7, line 25. Okay, I'm gonna stop you right there. What does this mean to you? Answer, that means that he's gonna kill me. He's gonna kill me. Now, is he alone? Answer, yes. You recall being asked those set of questions and given that answer?
Yes.
But you testified here on direct examination this morning that Nene was up, correct? When he was threatened.
Your Honor, objection, that's Rick's characterization of the facts. The witness testified that Mr. Brown was creeping
No,
along.
he's not there.
I haven't gotten there yet.
He isn't there yet. And
And that's
this
what's confusing the
gentleman,
witness.
the witness stated that he was alone in his car. That's what he stated.
Correct.
So go on, ask your question.
But you didn't in August 11th of 2020, you did not tell that court that Mr. Brown was alone in his car, did you?
Mr. Brown was alone in his car in the driveway.
Please answer my question,
I
sir.
do not understand your
You
question.
did not tell that court on August 11th, 2020, that Mr. Brown was alone in his car.
I don't understand your question.
Well, you were asked, was Mr. Brown alone? You said yes,
Alone when?
when he was threatening you.
He threatened me on more than one occasion.
Let's talk about the
May
first
5.
occasion, and the
May
first
5.
occasion is in that driveway, correct?
Correct.
Okay, and when you were asked that after Mr. Brown allegedly threatened you, you were asked, was Mr. Brown alone? You said yes, correct? That's what you said at preliminary examination.
He was alone inside of his car.
You didn't
I'm
say
not
that,
speaking
though,
for
did
anyone
you?
else that was standing around. He was alone inside of his car.
But you never said that, is that correct, sir? I'll move on.
Move on, Mr. Harris. I got the transcript. I read it. I understand your question. I understand his answer.
Okay. Now, you told this court earlier today that Mr. Brown had his leg outside the car. Is that correct?
Correct.
And you also told this court that Mr. Brown did not get out of his car. Is that correct?
Correct.
I would report to page 8, lines 5 through 7, or lines 4 through 7. Question, Were you asked this question and did you give this series of answers? Question, is he doing anything while he's shouting at you? Answer, he's getting in and out of the vehicle. He's got the door open. He's hollering through the window. He's standing up. He's sitting back down. He's standing up and. When you asked that question, did you get an answer?
Yes.
Were you telling the court the truth today when you said Mr. Brown didn't get out the car?
At the time that he got out of the car, he was in the driveway for several moments. When I approached with Nene, he didn't get out of the car. But before I approached with Nene,
Sir, that's not the question
he had
I'm
been
asking.
standing.
The question I'm asking you, sir, is, or did you tell the court the truth today when you said Mr. Brown did not get out of the car?
Yes.
Okay.
He didn't get out of the car while I was standing there.
So you lied to the court on August 11th when you told that court that he was getting in and out of the car standing up.
No, I did
correct?
not.
You did not lie.
No.
Okay. You told the police that the alleged incident occurred at 16165 Steel, is that correct?
Yes.
And you told the court today that Mr. Brown pulled out of the driveway, is that correct?
Yes.
And drove with the right side of his car facing your house, correct?
Correct.
Okay. You never told the police that on May 5th, 2020, did you? That he pulled out of his driveway, that he pulled out of his
He
driveway,
did not pull out of his driveway.
out of the neighbor's driveway. You never told the police that, did you? On May 5th, 2020.
I don't recall.
Okay. And you never told the police that when he pulled out of the driveway and driving by 16165 Steel, that he was creeping, correct?
I do not recall.
And you did not say on May 7th, 2020, that Mr. Brown pulled out of the driveway when you talked to Detective Moore, is that correct?
I do not recall.
Okay, would you look at that document and refresh your memory as to whether you said Mr. Brown pulled out of his driveway?
No, there was never a question on here to ask me if he pulled out a driveway.
Would you look at that document and see if there is an answer that says that Mr. Brown pulled out of his driveway?
That's an answer, Your Honor.
It is not.
Just stated that there was no question, there is no answer.
Well, okay,
I understand that, but
let me see the document then. You were asked, what did he do to threaten you? Is that correct?
Yes.
Does that answer say that he pulled out of the driveway and creeped past your house?
Pulling out of the driveway was,
threatening-
does it say, does it say that?
no.
Next question.
Okay. And that document does not say also that you walked closer to Mr. Brown to see the car when he was creeping. Is that correct?
Correct.
Today is the first time you've ever told anybody that Mr. Brown was creeping in that car, correct?
Maybe the first day I used the word creeping, it's he's driving by slowly.
You've never told anybody that he was driving by slowly until today, correct?
I don't recall.
Well, you didn't say that at the preliminary exam on August the 20th, 2020, is that correct?
I do not recall being asked that question.
you testified on August 11th, 2020, you indicated that Mr. Brown was still in the driveway of 16175 when he pointed a gun at you. You remember that testimony?
I do not.
You recall being asked this question and given its answer, page 15, lines 15 through 25.
Hold on, let me get there. Go on.
Question. Her grass in order to get to Mr. Brown's car, which was parked in her driveway on the left. Answer, not to get to his car. She called me over. She met me on the lawn. She asked me to walk to her, walk to the way.
That's clearly typed wrong.
Yeah.
Asked me to walk to her walk away to the walkway to my front door. There's a repeat here that's inadvertent, I trust, by the typist.
And there's a piece of grass, and then there's Daniel Brown and his car. He parked his car with the face of the nose of the car facing towards the backyard, and his driver's side door was open to capacity. And that's how I'm engaging with Mr. Brown on her walkway with the grass between us, and she's standing somewhere between us, and he has his door open, he has one leg out, and he has his right hand concealed at first, and he's talking. He's upset, saying some people on their way. That's not my gun. He's on the phone with some people saying, come over here, pull up. I asked him, I said, who you talking to? He said, this person whose gun that was, and it's going to be a problem, and it ain't going to be, and you ain't going to be able to live here. He was still, to me, they're gonna die, this and that. Next question. And when you see the weapon, is it in his right hand? Yes. And so his right hand would have placed the gun the furthest distance away. You correct answer, yes. And did he get out of the car? He stood up. Were you asked that question and were you given those answers?
Yes.
You agree with me that that's different than the testimony that you had this morning about Mr. Brown driving past your house creepy, correct?
Yes.
And so were you telling the truth on August the 11th, 2020, when you answered those questions, when you were given those questions and given those answers that I just read?
Yes.
And were you telling the truth today when you said Mr. Brown was creepy and you never saw a gun pointed at you?
Repeat your rephrase your questions, because you kind of.
Were you telling the truth today when you testified on direct examination that Mr. Brown was creeping in his car and you saw a gun, but it was not pointed at you?
Yes. That's true.
Okay. So did you tell the police on May 5th, 2020, that Mr. Brown pointed a gun at you?
No,
Brandished a gun at you?
I do not recall exactly where I worded it. I did tell the police that Mr. Brown
Well, if you,
showed a gun.
well, if you're
He
talking
had a
about
he had a
wording,
gun.
did you specifically say that to the police on May 5th, 2020, that Mr. Brown made multiple threats to you and his family and brandished a black .40 caliber handgun inside of his waistband after being told to leave the location? Did you tell that to the police on May 5th, 2020?
Yes, they may have changed some of the words a little bit. When you tell a story, the officer asks you multiple stories, some of them type of things different. Yes, I told the police that he brandished a gun and he threatened my family. Yes, I did.
And did you tell the police that that took place at 16175 Steve?
No, I told him that it took place at 16165, because at the time he was in front of my residence. He came from that driveway and drove past my residence, still in the argument of what he was mad about to begin with. And drove very slowly.
Okay, so on May 5th, 2020, you never told the police about this situation with Dee calling you over, Dee calling you over, is that correct?
They never, correct.
Never said a word about your neighbor.
I don't recall everything. Several officers asked me things. I don't recall everything that I said to them, but a lot of them had different questions about different timelines.
You know, it's interesting, sir. You don't recall a lot of things here on cross-examination, but you were surely specific to recall exact wording of Mr. Brown from May 5th, 2020. Is that true? Today?
Stop.
Judge, argumentative.
Sustained, argumentative, there's not a question there, sir.
Okay. You remember testifying today to exactly what Mr. Brown has said to you on May 5th, 2020, correct?
Somebody tells you they're going to kill you or shoot a house with your kids, you're not going to forget that.
Did you write that down somewhere, sir?
No.
Did you write those statements down that you remember about what Mr. Brown said to you specifically? Did you write those down?
I do not recall.
You never told the police on May 7th, 2020 about DD, correct?
No, because they asked me a specific line of questions and Dee wasn't one of them.
They asked you specifically what happened on that day, isn't that correct?
Yes.
And you never said, well, I was at Dee Dee's house and this Mr. Brown pulled up in the driveway and then he pulled back out of the driveway after he made some threats to me, correct?
It was made clear. It was made clear that a lot of irrelevant details were not necessary. They asked specific questions and they didn't allow any of the unnecessary details because I don't know why.
So are you saying that Detective Nicole Moore told you that I don't want a whole lot of details?
No, that is not
to
true.
this? Is that what you're saying?
I am not.
Okay. Now, first time you ever talk about Dee Dee is when you're asked on cross-examination on August 11th, 2020. By
And you
Mr.
asked me
Brown's
about it.
former attorney, correct?
It was asked by you.
No, it was
Well,
not asked by me.
I apologize. It was someone with him asked me about her. I assumed it was you because you are his attorney. I apologize if I misrepresented.
Please listen to my question. The first time that you tell anyone about Dee Dee, i.e. Deborah Walker, is when you are asked on cross-examination on August 11th, 2020 by Daniel Brown's former attorney.
Page
11, line 11 through 19.
I'm not sure when the first time I was asked about Dee.
Next question.
So you're answering the yes or no?
It is, I don't know when is the first time. That, I don't remember the date that she was brought up. I don't remember, but I know that she was brought up. I do not remember when or by whom exactly.
And the first time that you tell anyone about the incident occurring at 16175 Steel, Dee Dee's home, Deborah Walker's home, driveway, was on August the 11th, 2020, correct?
No,
You didn't tell the police about Dee Dee calling you over on May 5th, correct?
they didn't ask me if she called me over.
Okay.
They just asked me, was anybody else outside or present? And then I said, my neighbor was outside. What's her name? Her name is Nene.
Did you tell the police that on May 7th, 2020?
Told them that on May 5th.
Oh, you did?
Well, no, truthfully, I do not remember the specific date on which I told them that. I don't remember.
You don't
Cause,
remember?
cause.
Well, I'm gonna hand you a
You
document,
have to
see if
tell
it
us-
refreshes your recollection.
Mr. Harris, haven't we gone through this over and over?
Judge, I was literally going to object this. This has been asked and answered so many occasions already.
I don't think so, Judge. This is
Well,
the
this,
first time it
that's
comes
the,
up, Dee Dee.
that's the 5-7 paper that you handed him a couple times. That's the 5-5 police report, correct? Let him take a look at it, but I'm not going through this another time. Just read as much or as little as you need to, sir.
Does that refresh your recollection as to what you told the police on May 5th, 2020?
Let me see it again.
He's handing it back to you now, Mr. Harris. Please repeat your question.
Does that refresh your recollection as to what you told the police on May 5th, 2020?
On that paper, yes.
Okay. You didn't tell the police that about Dee Dee on May 5th, 2020, correct?
Correct.
Your Honor, I think this might be a good place to.
Well, I was given it a couple more minutes, but if you're gonna change your thoughts or go to a different section of cross-examination, we may. When I called the officer up, I questioned him as to whether or not I had any defendants in the back. I did not.
Oh,
So he gave me permission to continue until 3:45, and then these officers have to assist other courtrooms. However, if we're gonna take a break, let's do it right now, because I still have to consult with Mr. Bowman regarding the next date. And while I have exhibits B through E in my hand, I'd like permission to ask the question, gentlemen. Okay? I just want to make certain regarding the issue of distance. I'm going to hand you exhibit B. It is the front view of 16165. I think I said the address, 16165.
Correct.
Deal. When I am facing this house, this driveway right here, so I'm facing the house to my right, is that your driveway or the neighbor's driveway?
That is my driveway.
Because when I looked at all of these, you still can't tell on any of these whose driveway is whose.
In the picture where there's two houses, I can show you.
No, I think I've got it now. So exhibit C is two houses,
Yes.
your sidewalk, your driveway, the neighbor's house, the neighbor's driveway. I got it. And the court is focusing my question by looking at the house. And the driveways are to the immediate right of the house. That's all I wanted to ask, so that we've got the distance down. Number of witnesses more, Mr. Prosecutor.
My only witness, Judge.
All I'm asking,
I guess,
I'm just asking how many witnesses you're calling. You might have endorsed other witnesses if prosecution, if defense wishes to cross-examine them or question them. Fine. Do you have any other witnesses other than this gentleman?
it may depend on the court's ruling on the motion limited.
I guess we'll get there.
Right. Also, Judge,
Let me ask you this, because, go on, sir.
I would indicate for the record that the evidence tech who recovered the weapon on medical leave with broken ribs or something. I learned that this morning. That's what I was conferring with co-counsel about this morning. However, yeah, I don't know what his status is in terms of.
I understand. I just want to get my bearings on length of time.
Sure.
This witness, potentially another witness.
Yes, Judge.
Mr. Harris, your pleasure, and I am well aware that you are not standing in cement, and the decision as to whether or not perhaps Mr. Brown takes the stand can't be determined at this time. With the possibility of Mr. Brown, knowing that exists, will you be calling any other witnesses, sir?
Or including this.
Four, including Mr. Brown.
And one of those witnesses will be like Dr. Correct. Very sure.
The gentleman we already took testimony from?
No, Dr. Green, he's on the list.
But you used that other doctor's last name.
Yeah, but I'm saying he'd be short like Dr.
I understand. So a doctor with a different last name will be called, but very short, like the doctor we heard from. +2 plus the defendant.
Yes.
Okay. Let me go get an full answer. Mr. Bowman. I think that would be wow. I saw it. So just look for a day. I'm gonna let this gentleman sit down. Not a full day. I can't envision a full day, but we can't have a day like today where we had an emergency interruption. He's looking. Counsel, I'm gonna return the defense exhibits to you, Mr. Harris, or I can leave them in the legal file, which is never leaves this room at this time.
Your Honor, I'd ask that you leave those exhibits in.
I can leave them in the file, and we don't refile the file while a case is pending. They're always gonna be in this room. And I'm just gonna go remind Mr. Bowman that it does say a day and a half on this sheet. Sure does. 1.5 days. Got it. No. I know, I got it. So that's it. All right, gentlemen, we have evidentiary hearings in the afternoon of the 13th and 14th of June. We're gonna set this in the morning. We're not gonna set anything other than emergencies.
Judge, I am in a trial of Washington County on June 15th.
How about 14? I gave you both options.
Assault with intent to murder case.
So it's gonna go both days.
It's gonna go probably.
Got it. Mr. Harris is already booked in trial. 22nd of June, gentlemen.
22nd works then.
Perfect. Mr. Andre, you're not on. This is where your schedule is considered. June 22nd, Mr. Andre.
Yeah, that works, Judge.
Any reason why you can't be here June 22nd?
There's not.
Good. Okay, we are gonna set it in the morning. Everybody show up at 9 o'clock. We are only gonna do emergencies and we never know if we're gonna have any or not. Everybody here, 9 o'clock in the morning. We do not need to send you another subpoena, sir. Subpoenas are continuing, so I expect you to show up.
I'll be present.
All right, anything else? Now, I want, wait, my sheriffs have got to go. I want to make one thing crystal clear. That Mr. Brown is not to be having any contact with any witnesses, potential witnesses. I don't want to know where you live, sir, but you are, I don't want to hear that. No contact, you, your friends, your relatives, or agents with this gentleman cannot be on anywhere near where he lives. That's a condition of release. Mr. Harris, you're going to discuss it with your client. Yes.
My client is complaining that this gentleman doesn't live anywhere. He's squatting everywhere. So that would.
I'm not taking that. I am telling him that his release is contingent. I can't think of how to pronounce your last name.
Herndon.
You are not to have any contact with Mr. Herndon. If you should go into a restaurant and see Mr. Herndon at a seat at the table, it is your job to turn around and walk out. I'm not asking what his address is.
I understand.
He is to have no contact with Mr. Herndon. Mr. Brown, his friends, his relatives, his agent. It's a contingency of release.
Okay.
Period.
Your Honor.
Yes.
Can we have a copy of a transcript of this proceedings?
You can order one. Order one. It's plenty of time between now and the next date, and I can't recall. June 22nd, is that what we decided?
Yes.
You can order a transcript. Okay, my sheriffs have to go.
Okay,
All
thank
right.
you very much.
So let's do this. And I want people separated in the halls. However you wish to do this, you want to take him up on an elevator, down on an elevator. No contact, Mr. Brown.
No, if Mr. Hertzing can walk down with Detective Moore.
I don't know who's here, sir.
She should still be in the waiting.
But I don't even know these things. I don't know who else is here. Sir, you're free to leave. You're free to leave.
Thank you for
I'm
your
gonna let you go.
presence.
Take the mask present. No, it's yours. It's yours. Walk out with it.
Bring it back on June
I have
22nd.
a question. Is he excused or is he back on the bench?
He's good. He's excused for today, but he's coming back to testify. His testimony is continuing. Mr. Harris, you and Mr. Brown dawdle until this gentleman leaves the building.
Can I check with my OIC about the date? I'm sure she'll be okay, but.
Yes, quickly. We're gonna check with the date with the OIC before we go off the record.
This is not an expedited transfer, right?
No, it can be 2 days before.
Okay, I'll.
Yeah, a week before, but I'm not expediting it.
Because
I don't need to know. Yeah. Mr. Harris,
Yes.
Madam stenographer is speaking to me about the transcript. We're gonna have you the transcript. Today is April 27th. The next date isn't until June 22. I'm not expediting it. I'm gonna have it due to you on or about 30 days from now, but no later than a week before the next hearing. Satisfactory?
That's fine.
There you have it. Officer, open the door and ask that, I just need one answer from him. June 22, okay for the officer? June 22, okay for the officer, Mr. Andrea? That's all I need, yes or a no? June 22, okay for the officer?
Judge, yes.
That's all I need.
We're going back on the record.
I'm already on, I'm still rolling.
On this one.
Okay, go back on your record.
We're on the.
All right, we're still on the record. Court is indicating that officer, Mr. Andrea checked with his officer. June 22nd is good. I spoke to the timing of the transcript. I am not expediting it. There is about 7 weeks between now and the next hearing date. It will be to you on or about 30 days, but not later than a week before the trial. And Madam Davis has indicated that she can manage that time frame. All right, we're done. That completes this hearing.
Thank you very much, sir.
Thank you, Your Honor.
Off the record.
Good afternoon, Mr. Cantor. I do see that you're here. We are resuming our afternoon docket, and you are checked in. Have you had an opportunity to speak with Micah Buchan and John Zachi?
Good afternoon. Unfortunately, I haven't been able to be in contact with either one of them at the phone numbers that were supplied to me. I've left
All right.
voicemails, but haven't talked to them.
All right, we're gonna call the cases, quick. Okay. All right, Wisser, are you here?
I'm here, Judge.
All right, Mr. Glacier, I see that you're here. Which one of the prosecutors is handling Glacier's case? Jacob Bloomers and he's Ramsey. And Bloomers is here. I want to start with Glacier and Bloomers. You guys are all done.
Judge,
Yes?
is it possible I could go in a breakout room very briefly for Mr. Clear, please?
Yes, of course, but your guy does not have his video on.
That's fine.
Well, but he's got to turn it on before he gets in the room. There's some snafu that if it's not turned on, he's good now. There you are.
Perfect.
The room's open for you.
Thank you.
I'm okay if you go, Miss Davis.
No,
All right.
I can stay with you today, Judge, until 5 o'clock. if you want to.
Oh, let's not go there. I'm about ready to do a violation.
Okay.
Good to go?
No, just one thing. I needed to make a copy. I can give you that. Who is it now?
We're gonna do John Z-A-C-C-H-I.
Oh, the last.
Yeah. I don't know where it is.
I mean, the
Good.
last page. Yes.
Ready? Oh, you know what? Stop. Hold on. I'm sorry. Turn it off. Okay, good. You guys, I'm calling another case. Go ahead.
Calling case 18-9171 in the matter of the people of the state of Michigan versus John Zachi, here today for show cause hearing. Appearances for the record, please.
Good afternoon, Your Honor. Brittany Wister on behalf of the Probation Department.
And good afternoon, Your Honor. Robert Cantor, P number 24993, appearing on behalf of John Zachi. I was appointed this morning for this hearing. I have tried to be in contact with Mr. Zachi at the phone number that was supplied to me. All I got was a recording. I've left my voicemail messages, but have not heard from him.
Let me ask you a question. When the recording comes on, does it identify, hi, this is John, et cetera, I'm not available? Is there any identification as to who is ownership of the phone?
No, there's not, Your Honor.
All right, Ms. Wisser, I'm assuming that you've sent the documentation to Mr. Cantor and the phone number. Do you know anything that we should know?
Judge, I did send him the number that is in our system. I would note to the court that Mr. Zachi did report on 4/14 of 2022. At that time, he did report that he was homeless and he was staying with a friend in Detroit. They went over his show cause hearing coming up. So I cannot inform the court why he is not here today since he was told of this hearing. He is scheduled to report tomorrow. I don't know if the court would like to adjourn this matter, see if he does report, and then if not, issue a habeas.
All right, today is what, Wednesday, the 27th? He's supposed to report tomorrow. Mr. Cantor, are you free to come in on Friday just to make sure that he has reported? If he's reported, then obviously they're going to ask for a verification of a phone number, and I could conduct the hearing on Friday. If he doesn't show up and he doesn't report, I'm issuing a warrant. Are you available Friday, sir?
Yes, I am, Your Honor.
All right. I'm probably overbooked. I'm going to schedule this at 2:30 in the afternoon. Okay with you, Mr. Cantor?
That's fine.
I'll see you then. I'm not going to issue a warrant today. Let's see if he reports. Let's get an accurate phone number. Tell him he is to appear by Zoom at 2:30 on Friday. Failure to do so, failure to report will result in a warrant. Thank you for your patience, Mr. Cantor. We're going to go on to your next case, but off of this record, off the record.
Okay, thank you.
Did you sign the appointment? I did, but I didn't sign the warrant. Okay. Let's do Cantor's other case and Whistler's other case. I need a second. I gotta. Okay. Sorry, Miss Davis. Okay, ready? Are we ready? Oh, let's.
The court is calling case 18-9323 and 18-9867 in the matters of the people of the state of Michigan versus Micah Buchan here today for show cause hearings. Appearances for the record, please.
Good afternoon, Your Honor. Brady West on behalf of the probation department.
And good afternoon again, Your Honor. Robert Cantor appearing on behalf of Micah Buchan on both cases. I was appointed this morning for Mr. Buchan. I've been unable to establish contact with him. There were 3 phone numbers supplied to me for this. The only one I could leave a message on was the 3rd number, the 248 number, and I have not heard back from Mr. Buchan.
There are 2 files. I'm struck by the fact that Judge Michael Hathaway's signature is in one of the files. And it's interesting because it's not even Judge Hathaway's signature, it's somebody else's signature for Judge Hathaway. Miss Wisser, are both of these cases on my docket?
Yes, Judge, from my understanding, they are.
I think that it's potentially possible that he may have pled at the arraignment court on 9323 and the case was transferred here. On the other side of the coin, you know what, these might be, I can't understand it. All right, but needless to say, Ms. Wisser, tell me the status of the defendant. Is he continuing to report as instructed on probation?
So Judge, there is some concern with Mr. Buchan. It looks like he did just report on 4/21 with the next report date of May 27th of 2022. However, when I ran a when it was brought to my attention that he was arrested by Canton Township on 4/14 of 2022 for a felony dangerous drugs and a retail fraud. He's not currently in custody with them. I did call Canton PD and spoke to the sergeant there. He's not in custody. He was released, but there is concern with the show cause being that he has allegedly tested positive for substances, has not maintained employment, has not paid his fees and costs. He's been on probation since 2019, has not paid a dime towards any of these dockets and had prison guidelines, which were 19 to 57 on both dockets. I would ask the court today to issue a capias warrant due to his arrest, him failing to notify probation about this arrest. He reported on 4/21. That would have been after his arrest on 4/14, and he never made any report that he had police contact, was allegedly arrested. And we have a police report that does say he was in fact arrested by Canton PD. So I would ask the court today to issue that capias warrant due to his failure to appear.
Comments, Mr. Cantor?
Your Honor, I'll leave it to the court's discretion.
And he was notified of today's date, Ms. Wisser?
Yes, Judge.
All right. The court is going to grant the request, and the court is troubled by many things. There was a Cobb's memorandum that was sent to this court that alleges that the defendant's mother died of a drug overdose 6 months ago. And Mr. Buchan recognizing that this would be his fate if he doesn't conquer his drug addiction. There are allegations that he tested positive for both cocaine and opiates. That there is an admission to continued drug use, marijuana, and Suboxone. So the court certainly is concerned about his health, safety, and welfare. There are allegations that he failed to report earlier on April 30th. Actually, that's a 2021 date. So he's had previous violations of probation. So he certainly understands the drill. And obviously there is another document forthcoming about recent police contact and arrest. One of the basic terms and conditions of probation is to notify the court and or the MDOC field agent of police contact, and the court's going to indicate that he's on probation in 2 files. Prison guidelines, certainly a term of probation is a conditional freedom in his circumstances that requires full compliance, and the court's issuing an order to take him into custody, brought before the court, temporarily placed at Wayne County Jail pending hearing. Mr. Cantor, obviously you've left the messages on 3 different phone numbers. If he contacts you back, I would certainly welcome it and consider it a positive circumstance if he contacts you, and I would allow a potential for a surrender on Zoom. Be in touch with us if you need us, Mr. Cantor, and I'm going to keep you on the case should he call you.
Okay, I will, Your Honor. I'll notify the court if I hear from him.
All right, thank you.
Thank you.
Off the record. Okay. Mr. Cleary's file. Everybody ready?
The court is calling case 19-7806, 19-6899, and 21- the State of Michigan versus Roderick Clear here today for 2 violation hearings and a final conference. Appearances for the record.
Jacob Bloomers on behalf of the people.
Good afternoon, Your Honor. Jeffrey Glazer, P 46892 on behalf of Mr. Cleary on all files. Judge is here via Zoom asking to waive his physical presence. We consented Zoom.
Mr. Cleary, your name?
Roger Jamel Clear Jr.
Thank you. Ms. Wisser, you're on the 2 violations. Your name for the record?
Yes, Your Honor. Good afternoon. Brittany Wester on behalf of the probation department.
Mr. Glacier, this has been the status for a considerable period of time to hold the violations in abeyance until resolution of the 21 file before the court. Any objection?
None, Judge.
All right, Ms. Wisser, you're welcome to stay and you're welcome to, I'm not going to go into the violations today. So.
Thank you, Judge.
All right. Mr. Bloomers, I'm almost certain that we have placed an offer on this record and where a decision must be made by the defense, Mr. Glacier, as to whether or not your client wishes to proceed to trial and certifying this case as trial ready. And perhaps I'll go backwards and ask Mr. Bloomers if there's any changes to the offer that was placed on the record previously.
Yes, Your Honor. We actually adjourned this last time as defense was seeking a better offer. And the offer now would be to plead 2 counts 1 and count 3. Counts 2 and 4 would be dismissed, and the parties would agree to a sentence of 3 years probation, no contact with either complaining witness and batterers counseling.
Okay, well, the last offer counts 1 and 3. However, it was a guidelines and the guidelines were prison guidelines.
Yes, Judge. And so the sentence agreement of 3 years probation would be the amendment to that offer.
Got it. I understand. No contact with the complainants, batterers counseling, etc.
Yes, Your Honor.
Mr. Glacier, please confirm, Mr. Glacier, that I gave you an opportunity. You did speak to your client in a breakout room prior to going on the record, correct?
I did, Judge, correct. Thank you.
Your client's pleasure here today, sir.
Judge, I convey that offer to my client, Judge. I believe he understands, and I went over with him a few times. And he's going to decline that offer, Judge.
That's fine.
Is that correct, Mr. Clear?
Yes.
Do you need any more time to think about it, or is this your decision?
That's my decision.
All right, Mr. Clear, just a friendly reminder. Once a case is certified as trial ready, Mr. Clear, there are no further negotiations. You're going to go to trial as charged. Home invasion, count 1, first degree, is a 20-year statutory maximum penalty. Count 2 is malicious destruction of a building, 200 or more, but less than 1,000. 1 year statutory maximum. Count 3 is the misdemeanor domestic violence, 93 days. Count 4, assault and battery misdemeanor, 93 days. If convicted as charged, the guidelines would be based on count 1, home invasion, first degree. They are prison guidelines, Mr. Clear. 30 to 50 is what I wrote down before. There might be
Judge, can I
30 to 50. I just want to comment, there might be some argument about guidelines, but I am assuming that they're close to accurate. Yes, Mr. Glacier?
I apologize, Judge. I know Mr. Bloomers did a lot of work on this. I got the offer late Monday afternoon. I've been trying to get in touch with Mr. Clear. His phone number had changed. I have his new phone number now, Judge. And I'm going to be back here May 6th for Ms. Baxter. I don't know if the court's inclined to give one last adjournment just for he could think it over. I just don't want him to make a rash decision on this.
No, I understand what you're saying. I didn't know that you just had the offer until Monday. And I'm assuming then what you're telling me is because of a change of phone number, you just conveyed it to him when you were in the breakout room on or about 30 minutes ago.
That's correct, Judge.
All right, Mr. Clear, I want to remind you, Mr. Clear, that you are absolutely required to notify your counsel of any change of address or phone number immediately. But I think that your request is fair, Mr. Glacier. Mr. Glacier, what time do I have? And I don't want her name on the record. I know the other case that you speak of. What time are you scheduled in front of me?
I believe it's 3:30 p.m., Judge.
I'll see you at 3:45 on this case, May 6th.
Very well, Judge.
Okay. And Mr. Talk to Mr. Glacier, think about it. Nobody's twisting your arm to get you to plead guilty. You're presumed innocent. I'm happy to give you a third jury trial in front of me. I just want to get an answer from you. There's been a lot of delays in this case. If you take the offer, fine. If you want a jury trial, you're presumed innocent, have an absolute right to a full trial and full hearing. It's just my job to tell you everything. There's an offer. I think you deserve time to think about it and have sleep on it, ponder it, and discuss it more than you have today. And I agree with Mr. Glacier. If you just got the offer, you should force to make a decision in 5 minutes or less. So I'll see you May 6th at 3:45, but I certainly want the record to reflect what the guidelines are. I know that they're discretionary. They are certainly something that is that the court must consider and evaluate. Anything else, gentlemen?
No, Your Honor. Thank you.
Nothing from the people. Thank you, Judge.
The only thing I was asking was these tethers.
Okay, but I'm not going to deal with the tether today. Mr. Bloomers, let me ask you a question. I didn't get your acquiescence to the date and time.
That's a good day for me, Judge. Thank you.
The May 6th is around the corner. Mr. Glacier, we can discuss the tethers at that date and time.
Very well, Judge. Thank you so much, Your Honor.
And Mr. Glacier, you understand that he's out of custody. I know I have an alcohol and a GPS tether on him, and that has been previously litigated, and there is a record to support the reason thereof. I can't do another DSU report because we don't do DSU reports on gentlemen or defendants who are not in custody. If you want to provide some supportive documentation by way of a motion, you're welcome to do so. But I would strongly urge, if there's going to be a motion to allow me consideration of removal of the tether, that you might want to provide the court with supporting documentation as to why I should do so, Mr. Glacier.
I'll talk to Mr. Clear, Judge, and we'll figure out which direction to go.
You understood what I said, and if you present it to me, you must present it to the defense, to the prosecution.
Of course, Judge. Yes.
That completes this hearing.
Thank you.
Your Honor.